like to welcome I'd like to welcome everybody to the Blue Ribbon Commission on the Future of the Bar Exam regularly scheduled meeting. Call the meeting to order. Devin, can you please call roll?
Yes. Susan Bakshian,
Present.
David Boyd,
Present.
Alex Chan,
Present.
Charles Dugan,
Present.
Jeremy Evans, Jackie Gardina,
Present.
Ryan Harrison,
Present.
Dr. Henderson,
Present.
Esther Lynn, Tracy Montez,
Present.
Judge Reeser,
I'm present.
Natalie Rodriguez,
Present.
Kristen Rossi,
Present.
Emily Scavalletto,
Present.
Karen Silverman, Mylan Spencer,
Present.
Amy Williams,
Present.
Josh Pertula.
Present.
We have a quorum.
Thank you. We're going to begin today's meeting with public comment. I have been asked, so please bear with me, to read a new policy. The Board of Trustees recently adopted a public comment policy that applies to all sub-entities, including the Blue Ribbon Commission. The policy statement is: the State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. These public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct business on behalf of the people of California in a timely fashion. Members of the public were encouraged to submit written public comment at least 24 hours prior to the start of the meeting. Written public comment received less than 24 hours prior to the start of the meeting will be distributed the following business day. Members of the public were encouraged to sign up to speak in advance of the meeting and will be called in the order they signed up. Members of the public attending the meeting remotely will be called in the order they appear in the attendee list. Members of the public cannot cede their time to another speaker. It is not guaranteed that all who wish to speak will be able to do so. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers and to allow the Commission the time needed to deliberate on the important topics that we'll be discussing today. We will be limiting public comment to 3 minutes per person. Please note that there will be an on-screen countdown timer visible for all attendees on the timing. The State Bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. The State Bar will not tolerate harassment, discrimination, or retaliation against its employees, job applicants, or members of the public by any employees or by any person with whom the State Bar has a business, service, or professional relationship. Before I get into the logistics of how to raise hands and we start the public comment, I just want to provide everyone with some background on what we are looking at today. I think we know the report was developed by staff to document the discussions and the actions of the Commission over the last 17 months. The draft report spells out various factors commissioners explored to reach their own conclusions. Commission was asked to weigh in on whether attorneys from other jurisdictions should have to sit for the California bar exam to be licensed, as an example. The purpose of the report is to provide the State Bar Board of Trustees, the Supreme Court, and the public the opportunity to understand what information was considered and how it led to the recommendations that are being made. I think everybody knows that the next step here when we are done today is we're going to go out for public comment on this, on the actual report that is agreed to, we will then reconvene after that time. For the benefit of the public, I just want to clarify what you're seeing in the report. The report was posted for this meeting. It contains a handful of strikeouts, insertions, and comment bubbles. Those are comments that were given to the State Bar by one or more of the commissioners and reflect the thoughts. We're going to go through those today and see if we can't come to some agreement on a final report. With that, I want to touch on the logistics for raising hands. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. The coordinator will call members of the public, starting with members who have signed up to speak, and then for all others in order that they raise their hands. Staff will enable the microphone of the speakers. You will see a timer on the screen showing the amount of time you have. At the conclusion of the 3 minutes, the coordinator will move on to the next speaker. Okay, at this time, are there any public members that wish to make comment? Devin?
Yes, we do. So our first public comment will be from Benjamin Cohn.
Hello, thank you. I wanted to first express my disappointment that there was not a consensus made by this commission to recommend a non-exam pathway to the California Supreme Court. I think that that option would enable people who are indeed competent to demonstrate that and should have been recommended. But I'm especially concerned that not enough consideration was given when deciding to effectively only recommend an altered exam pathway to the costs of doing the exam pathway, and maybe even a perception that I believe is mistaken that the non-exam pathway would cost more to develop and administer on a per applicant basis than would the non-exam pathway, and that the state bar should focus, given resource constraints, on the programs that it's already struggling to fund. The exam pathway is already causing a budgetary crisis in the Office of Admissions because costs have been rising, and those supposedly rising costs don't even account at this time for the costs that would be needed to comply with disability law, which the Ninth Circuit has recently signaled at an oral argument the state bar is not doing well at complying with, and would lose absent sovereign immunity. The per applicant cost of an exam pathway would increase quite a bit if the state bar complied with its obligations under disability law, and I don't think it would be quite as proportionate of an increase for non-exam pathways, which don't tend to have the same impact on people with disabilities at functional limitations as does licensing exams and standardized tests. So even if you can't reach consensus, I would urge you to ask the California Supreme Court to take up the issue and to consider the near 50-50 split in opinions on all of the proposals that were considered by the commission when considering those motions. So I think the report should emphasize it a little bit more than I see in this draft. Thank you.
Thank you. Our next public comment is from Claire Solot.
Good morning. I'm Claire Solot, and I am the co-founder of the Legal Services Funders Network and oversee the LSFN Public Interest Bar Fellowship. Over the past 3 years, more than 85 new law school graduates have participated in our program, which is the largest public interest bar fellowship in California, if not the country. There are 3 major issues I wish to comment on: expanded use of the existing PLL program information, DEI assumptions, and BRC commissioner meeting participation and voting. First, the BRC was asked to include any information that may be gleaned from California experience with the temporary provisional licensure program to the extent that it is relevant to the commission's charge. Yet the draft report does not include key data from the State Bar's PLL survey. The addition of this data will both fulfill the charge and answer many of the red herring issues those who oppose exploration of an alternative pathway to licensure have raised. Next, the report highlights concerns some commissioners had that an alternative pathway will potentially reduce diversity in the profession. These allegations are absent any factual support. As noted in the report, the differences in bar pass rates based on examinee characteristics are extreme. There is no reason to believe that revisions to the California bar exam that focus on topics and exam format will solve the economic and cultural differences that impact performance on a multi-day in-person exam that requires months of intensive study and thousands of dollars of fees and bar prep courses. The reality is bar exams were designed for privileged traditional law school graduates, and I'm happy to report that we have a growing number of non-traditional law school graduates that seek to go into our profession. We need to figure out a pathway. Finally, and most importantly, BRC commissioner meeting participation and voting is suspect. The fact that many members of the BRC failed to turn on their screens during BRC meetings is very troubling to the public. When members only attend by phone, the public has no knowledge of when the commissioner joined the meeting, what other tasks the person is doing during the meeting, and what information their votes are based on. At virtually every meeting of the BRC, the public had no knowledge that certain commissioners were in attendance as they were absent during roll call and/or made no comments during the meeting, yet suddenly they appeared to turn on their microphones or computer screens when it was time to vote against an alternative pathway to licensure. Based on a dissent to this report in which the author now appears to support exploration of an alternative pathway licensure from 2023 to 2026, the group of commissioners who acknowledged that they were on the fence when they voted not to explore an alternative pathway to licensure, the impact of the non-exam nomenclature, and the power dynamics of the BRC, it is my belief that the vote not to explore a pathway to licensure does not reflect the majority of the BRC. I urge that the Board of Trustees disregard these votes and that they continue to support the recommendation to the Supreme Court to explore an alternative pathway to licensure, which would commence with a pilot with the 2020 PLLs. Thank you.
Thank you. Our next public comment is from Jacob Shaw.
Hi, can you hear me?
We can, thank you.
Good morning. My name is Jacob Shaw, and I'm a recent graduate from law school. I just sat for the February 2023 bar exam. During my time studying for this exam, I often wondered how I could motivate the people behind it to test skills that are actually relevant to the practice of law, instead of the rote memorization of law I will never need in practice. I have read the draft report that your committee has worked on, and I am happy that you are considering reforming the bar exam, or even adopting alternatives to the currently administered exam. For those of you who may be on the fence about such reforms, it should be noted that the bar exam is definitely not a test of minimum competency. Even though most of the commission members here consider themselves competent, due to the current exam largely requiring rote memory, having little to do with competence as a practicing attorney, I highly doubt anyone on this commission would pass the current bar exam without extensive review and studying. This is simply because you have most likely forgotten the vast number of topics that you would be required to memorize for the bar exam, as they are useless to your current practice. This doesn't mean that you aren't already a competent attorney, or that the bar does not test for competency. I myself want to practice family law. I have spent over $5,000 in bar exam fees, bar prep materials, and lost time and pay from work to study for and take the test. During my hundreds of hours spent memorizing hundreds of rules and laws for the bar, I don't believe I learned a single new concept that would be useful to me in my future practice. Thousands of other applicants waste millions of hours and millions of dollars each year memorizing by rote material that is nearly useless to us and our ability to serve the public. Many people fail this exam that would have otherwise been perfectly competent attorneys. Every month you delay the much needed reform of this exam is another month of significant wasted time and money in service of nothing. Please hurry up and improve the profession by improving the way lawyers are admitted to the bar. I would like to leave you with a short list of proposed actions. 1, allow alternate pathways to becoming a lawyer without requiring the bar exam. 2, eliminate the rote memory MPE multiple choice exam. 3, modify the essay portion of any exam to focus on actual lawyering skills, including legal research and writing skills, largely modeled after performance exams that already exist on the current bar. 4, lead the nation with these improvements, starting sooner rather than later. Thank you for your time.
Thank you. Our next public comment is from Matthew Yanez.
Yes, hello, can you hear me?
We can, thank you.
Perfect, thank you. Good morning. I am commenting on behalf of Disability Rights California. As stated in the report, the recommended examination or examination alternative should be evidence-based. We commend the data analysis and recognition of the changing nature of the legal profession. However, we still see gaps within the current data that needs further analysis. First, we urge the committee to recommend not only to minimize disparate performance, but seek to firmly remove barriers that disparately impact race, gender, ethnicity, disability, age, ancestry, color, race, citizenship, familial status, marital status, gender identity, gender expression, sex and/or sexual orientation, and other identity groups that have been historically marginalized because of the hegemonic societal exclusion of such persons from the legal field. We urge the committee to view the combination of one, the lack of data between 1919 and 2018 on marginalized populations, including the complete lack of disability data. Two, the overwhelming data showing a declining of passage rate and much lower passage rate of marginalized groups. Three, the abysmal statistics on current California attorney diversity. And four, the fact that unqualified and unscrupulous individuals still remain, as indicated by the report's own commentary on, quote, civility needs, threats, and sexual harassment, racism seen from current licensed lawyers, unquote. There is overwhelming evidence that the exam format, question type, and delivery modes do not currently ensure practitioners are identified as attorneys who will be minimally competent. Standardized testing has long been empirically proven to be an insufficient indicator of intelligence or merit, and has been overwhelming disparate impacts on marginalized groups. Thus, we seek to comment that innovative approaches such as, but not limited to, portfolio reviews, capstone projects, client interactions, and supervised practice under a qualified attorney akin to a residency are a more equitable determination of minimum competency than an exam. We acknowledge the data displaying power imbalance in these alternatives to an exam. However, we also wish to acknowledge that a marginalized individual taking the bar will not be miraculously shielded from discrimination or power imbalances that occur as a young attorney in the field. We instead recommend the bar to seek to ensure adequate pay and requirements for supervising entities and attorneys. We also urge the committee that it must ensure solutions for greater portability and reciprocity for enhanced equity, and ensure an expert on such matters if BRC does not believe it is in a position to identify best practices. Thank you.
Thank you. We have no additional public comments.
Okay, moving on to 1B of the agenda. Thank you for the public comment. Let's begin with approval of minutes of the November 3rd, 2022 BRC meeting. Do we have a motion to approve those? Any modifications that need to be made?
So moved.
Second?
I'll second.
I'm sorry, Mr. Chair. It's come to our attention that there was a mischaracterization of one of the public comments in the in those minutes. The comment of Claire Solat with the Legal Services Funders Network was pointing to a comment that CLA made and not endorsing that comment. And so we would like to make that correction in the minutes.
Donna, what is the proper way to do that? Is it acceptable to do that orally at this point? Do they need to be modified and redistributed?
So the commission can vote to approve the minutes as amended to accurately reflect the comment of Claire Solat.
I would move with the and to vote on the minutes with the amendment that was identified by Claire Solat.
Second.
Great. Can we have a roll call, please?
Susan Bakshian,
Approve.
David Boyd, Alex Chan,
Yes.
Charles Dugan,
Yes.
Jeremy Evans,
Yes.
Jackie Gardina,
Yes.
Ryan Harrison,
Yes.
Dr. Henderson,
Yes.
Esther Lynn, Tracy Montez,
Yes.
Judge Reeser,
approve,
Natalie Rodriguez,
Approved.
Kristen Rossi,
Approved.
Emily Scavalletto,
Approved.
Karen Silverman, Mylan Spencer,
Approved.
Amy Williams,
Approved.
Joshua Pertula,
Approved.
and back to David Boyd.
Approve.
Thank you. The motion passes.
Okay, thank you. We're going to move to business item 2A, discussion and action on the Blue Ribbon Commission report draft recommendation. Before we begin, a couple of comments I'd like to make. First of all, we've been given a difficult task the entire 17 months, and it's not getting any easier today. There's 18 of us. Obviously, we have each our own opinions and some comments. Our goal is to come to some kind of consensus on this report where we can incorporate some of the comments and feel like we have an accurate depiction of what occurred and where positions that we took, and then put it out for comment, as I discussed before. I don't know that there's an easy way to go about that. What I would like to do is somewhat turn pages together on this report. But as we do that, I've tried to put together a more broad topics that seem to come up in people's comments. And so if for whatever reason you feel strongly about something that we miss, please raise your hand and we can go back to it. In some cases, there's not any way to cover everything. One of the things that's really important to me, and I think to all of us, is not to start relitigating issues that we discussed over the last 17 months. Those are, we've come to conclusions. You will all, each of you, have an opportunity to do a final dissent. We will make sure that those are, you're given plenty of time and an opportunity, both now when the document comes back and after, frankly, it's gone through the Board of Trustees. With that, I would like to turn first to pages 13 and 14. You will see we'll come back to a couple of the comments. Before we get there, there's really comments about civility that we're going to address right now. There seems to be some disagreement about the next gen. If you feel comfortable, it's your comment and you'd like to address it, please feel free to do that. I'm not going to be able to do justice and address everybody's comments, but I do want to at least raise them and make sure that we address them as a group if we want to. So I'm going to hit one of what I believe to be the comments that's been raised a couple of times, and that's civility was not included. Is there anybody that wants to address that directly?
Hey, Josh, it's Jeremy. Yeah, so I had sent a note in to the team just basically asking if we could include that in. And you know, I'm not as certain as to whether it was voted on or not. It sounds like, at least in the report, it didn't get brought up, but at least I thought that was pretty clear, and there was some consensus that we wanted to have civility and that sort of tested on the exam. I don't know how to fix that issue or what we can do to change that, but that was sort of my recollection of it. So thanks, Josh.
Yeah, you go ahead.
Sorry, this is Ryan Harrison. So I joined Jeremy Evans' comments, and I discussed civility and my dissent to the draft report and at somewhat length. And so I'm not going to restate what I already stated. I just feel strongly about the issue of civility and its decline in the legal profession, and that it should be tested on the exam. Thank you.
Amy or Donna, do either of you guys want to address this? I know that this came up in the comments. I know that you went back. I understand you went back and took a look at the conversations in the minutes, trying to determine exactly how it was addressed.
Yes. So, correct. Josh, we went back to the archives and to look at this discussion. This discussion took place, I believe, on August 6th. Essentially, what we discussed was which knowledge areas and skills should be incorporated in the California new design of the California bar exam. At the time, civility was not one of our discussions. I think the issues that were raised there were only one other knowledge area that was raised and discussed for quite some time is business associations. We also, in terms of the skills that were discussed, we talked about negotiation, alternative dispute resolution. And as you can see, some of that was added as a consequence of our discussion, but civility was not raised. I do think when we talked about the guiding principles as to what we were going to apply in the development of the Blue Ribbon Commission recommendations and throughout the discussion, civility was discussed in that context. But here, what we talked about the legal topics and the skill areas that was not raised during this discussion, and also was not included in the motion. So I just want to confirm that.
Yeah, Tracy.
I just wanted to add that civility is more of a construct. It's very hard to examine on a content-based exam, such as a licensure regulatory exam. So that's may have been a reason why it did not make the list, or it wasn't in the occupational analysis or practice analysis, I should say. It gets a little tricky when you're trying to test those softer type of skills. It's not that it can't be done, but it's, again, this should be more content related exam. That's it. Thank you.
Would it be appropriate? I do recall having a conversation about civility, and obviously I think we had a lot of agreement on it. Would it be appropriate, and this is really a question for Donna and Amy, would it be appropriate to add a paragraph that said civility was discussed, that it was not chosen because of a difficult topic to put on this exam format, but that there was agreement that it should be looked into other ways to improve it? That's just a suggestion. Mylin?
Could I ask, when you mentioned I think Amy, you said that it was discussed at the August 6th meeting? Sorry, give me 1 second. I'll come up with, let me confirm that. That would be great. And I guess I would ask that both within this meeting and within the report, we distinguish between the meetings that we had as a full commission and the meetings that we had in subcommittees, because I think it's misleading when we suggest that the entire commission was present or came to any kind of consensus if it happened in a subcommittee. And that's one of my pieces of feedback with the report as it currently stands. We really need to be careful about who was present for certain discussions and how much of a consensus or what a majority means within that context.
Ryan?
Yes, I just wanted to note that, well, two things. The first thing is what I heard from Ms. Nunez is that civility was discussed, just not at the right procedural moment in time when the vote was made on the specific subject areas that we would like to recommend being tested on the exam. And so I wanted to highlight that difference. It's not an issue that we didn't discuss it, it's that we didn't discuss it at the right specific time, according to Ms. Nunez. On the issue of the testability of civility, I don't think that we shot that idea down because we agreed as a Blue Ribbon Commission that it's difficult to test. I think that you know, again, we just may have not discussed it at the right moment in time, but we did discuss it. Regardless, there are rules that the state bar has around the issue of civility. There are certain statutes in the professional rules of the rules of conduct that if you break them, you can be subject to discipline by the state bar. At the very least, new attorneys have to swear an oath to civility along with their state bar oath. These are the types of things that can be tested. The rules that are in place that dance around the issue, the oath. They might not necessarily be overly difficult questions, but they are questions that require a candidate to study them, to learn them, and to remember them as they proceed into the profession. And I think we can at least do that much.
So I just want to go back. So the date of the meeting where we had this discussion in the full committee, because the motions that are incorporated here are motions. This motion was made by the full committee, happened on April 6, 2022. And in terms of adding this to the item, I think the concern is the report itself, like when you started, Josh, in our discussion today, it should reflect the instances that took place throughout this during this meeting and during the course of both discussion and action taken on by the BRC. I think adding it is, you know, this is something that happened now. I think what we're trying to do is provide the public and the court a lens of how the commission came to these decisions. And so I think adding it here it does not reflect that this was something that happened when this was discussed and when we brought forth the recommendations on which knowledge areas and skills should be tested on the exam. So I just want to put that out there.
Yeah, I have a recollection at that meeting as we laid out the areas which are outlined in page 18. We debated each of them. We removed some, we added some, and we came to a conclusion which turned into the motion and ultimately the recommendation. I do know civility was discussed, and that's why I was making a suggestion maybe we reference the discussion. But as far as adding it as a topic, we would be going back and doing work we've already done, which is what I think we're attempting not to do. Natalie, I'm sorry. Yeah, Natalie.
So my recollection wasn't so much around civility as much as professional responsibility, which is completely different. And there we discussed the reason we were not including it is because we felt it was adequately tested in other ways. So I don't know if maybe that's where it's getting mixed up, but it's professional responsibility that I remember us discussing and saying we would not include as a separate topic.
Emily?
And that's correct.
Emily?
Yeah, I'm echoing what Nally said, but also if Ryan and Jeremy, if you have a distinction, and I think there is, but if there's a distinction between civility and professional responsibility, and you want to talk more about professional responsibility, I totally understand that, but I don't think the commission has ever discussed whether or not to test civility itself on the exam. And so we did discuss thoroughly, I thought, professional responsibility as did the CAPA working group. And whether or not we agree on where we land on that, we did discuss it, so.
Jeremy?
No, thanks everybody for that. So Josh, I agree with your suggestion. I mean, if that's what the commission wants to do, that we have some commentary about there was a discussion around civility, regardless of how that wants to, go in there, but I think at least mentioning it. And then if I wanted to add any additional commentary, I could do that through a dissent or whatever, but
That's
I think
correct.
otherwise, I think your suggestion is great, Josh.
Okay, Natalie?
So, and maybe it's, again, this is what Emily was getting at, is that we mean the same thing and we're using the terms interchangeably, but I'm hesitant to say we should go back and say we had a conversation around civility when I don't believe we had a conversation about civility. We had a conversation specifically about professional responsibility. So I just want to put that out there that I don't think it's the same thing, and that's not the conversation I was having when we were discussing the topics.
Susan?
I agree with Natalie. I don't believe we ever had a discussion of civility as a topic on the exam. And I think adding it to the report after the fact violates the principle that you started with today, Josh, which is the report is not about what we want to discuss today. It is about a reflection of what we did. We did not do that. And I'm troubled when Amy and the state bar staff thoroughly review the discussion, do not find it present. It would be grossly inappropriate today to suddenly add a portion that says, well, we discussed it. When several of us are saying, no, we did not. We discussed professional responsibility, we discussed subject matters, and we discussed CAPA. There was not a discussion of adding civility as an independent subject matter or testable topic. And to add that to the report now, I think is revisionist.
That's not the intent, and clearly there's plenty of opportunity for people to dissent and add it. I didn't hear Amy say that. Maybe I misunderstood a little bit, Susan. I know very clearly it was not. I remember it not being a topic, and it may have been under the guise of professional responsibility. I can't speak. My recollection isn't that clear, but I do remember having a conversation about civility, and so that was why I made that suggestion. But I don't feel strongly about it. It's not part of the recommendations that we're making, and I think it'd be fine to be in the dissent. Ryan?
Yes, in the middle of page 7 of the draft report, there are the bullet points, and then it says in the middle of that, this small indented in paragraph, and I'll read the relevant words. Nonetheless, the Blue Ribbon Commission is committed to promoting the highest standards of integrity, civility, and professionalism in the legal profession, and its members will also be guided by these more general objectives. The reason why that sentence is there is because we discussed civility. Jeremy and I specifically spent like 15, I think, minutes discussing why civility was important. It may not have been at the right time, but that was added because we actually discussed the issue of civility.
Yes, that's correct. And it was in the context of the guiding principles, which is where it lies in the report right now. That's what I had started with, but yes.
Emily?
I don't have any objection to emphasizing in the report that we talked about civility in relation to our guiding principles, but I don't think it's a good idea to put in that we discussed testing civility, right? That there is that distinction. But aside of all that, I do think it's good to recommend that we keep looking at civility, because I agree with Ryan and Jeremy that it is a huge issue. I just, again, don't think that we are testing it on the bar exam as we have recommended. We haven't recommended to do that.
Okay, so this is a great example of how difficult this is going to be. There is no clear way to go about this. I'm going to try another suggestion, and then if there's dissent, we're just gonna leave this for those to address individually. Would it, and this is really to Natalie and Susan, who have raised some issues, if we address civility in the section that is currently addressed, but maybe teased it out a little more in the discussion around the mission and guiding principles, would that be an objective to you, or would you be in any way object to that?
Not at all. That's exactly where we discussed it. I think civility is important. It's a guiding principle, but it was not discussed as a testable subject. And I agree with Emily. These are distinct, and it belongs in distinct parts of the report.
I agree.
Okay, so Amy, Donna, if we can try to just make the record reflect a little more clearly that civility was discussed, not just as one of the topics, but specifically in the guiding principles. And then if people have additional issues, they can address it in their dissents.
Josh, can I just make a recommendation that I think a lot of us put in language that we thought we would like to see in the report. So maybe if Ryan and Jeremy don't mind submitting what they'd like to see, actual language to address that, rather than having Amy and Donna have to do that. Just a thought. I mean, maybe it's easier to just.
Yeah, I'm hesitant to do that, Emily. Donna, you have a comment?
Yeah, so I actually think it's going to be fairly easy to do it, because the original version of the guiding principles, which were brought to the commission, did not include that last paragraph. And based on conversations that were had at the commission meeting about civility and the importance of it, that's where that last paragraph that included it came about. And so we can break up that document, that part of the report, to say that this was what was originally presented. The commission had a discussion about the importance of civility and tease that out, as you said, and then say, as a result, sort of this additional paragraph was added to the guiding principles.
Perfect. That sounds great. Thank you.
Okay, I'm gonna move to the comment on page 14. It's specific about the next gen exam. It seems like there's a feeling of one or more. The current language of the report might misrepresent the discussions that commission had on next gen. Does anybody feel that way? Want to discuss it?
Which comment on 14, Josh?
NA3. It's the first comment on 14, NA3. Make sure that there's no specific issues with it. Okay, I'm going to keep going. The next comment, which is NA4, I have to tell you, I don't completely understand this comment. So if someone wants to address it, I'd be happy to have a conversation around it. It feels like, it's more commentary than a comment, and someone's opinion. So I want everybody a chance to address theirs specifically. If they choose not to, that's fine. We're going to keep going. But at this point, if we pass these and don't have any recommended changes, they will be removed in the as a comment and in the final document.
I think looking at this, it might have been me. It was commentary. It was opinion, and it's just something that I don't think I was able to fully express during our meetings for one reason or another. That I also included in my dissent to the draft report. So we don't really need to talk about it now.
Okay, great.
Josh, just for clarification, I want to make sure I understand that staff walks away with a clear understanding of our direction. With regard to comment 3, because we moved on, does that mean we are not including that change?
When it's a little hard for me, I apologize. We're all reading it together. When you're referring to the change specifically, some of these changes, I'm trying to figure out which ones you guys made on your own versus what you did in response to the actual comment. So where is the change that was response to the comment?
There was no change made. We added the comment.
Thank you. We're ignoring the comment. We're moving on.
Okay.
If you, and that was my understanding, but if there's a change that we need to discuss around the comment, please alert me.
Will do.
I do have I did print it, and I have a color printer, but my red and my orange, and you got a lot of colors going on here. Okay, I'm gonna keep going. The next, and please, if there's anything up until page 14, I think I've covered everything up until now. It was mostly civility, but if there's anything specific in the comments that we didn't cover that are yours, please address them. Let me know, raise a hand, and we will go back to it. Kristen.
Josh, can I ask a quick question?
Yep.
I'm looking at a color copy also and following along on the screen. And I'm trying to figure out some changes aren't attached to a comment and some are in purple. And I'm just wondering if we can get a sense of what changes were made that, or I guess the comments didn't change anything. So the changes that are in here, for example, it says the BRC was never privy. Now it says not able to view. Were those changes that the bar made?
I understand your question. Amy, can you address all the changes and the different?
Yes, so the changes that are underlined or appear as track changes in whatever color you might have, those are suggested changes that were made by commissioners that strengthened the document, that did not make any substantive changes to the overall intent of the document. And so that's what's incorporated there in the track changes portion. The comments are one where that we added where responding to the comment changes makes a substantive change to the document itself, and that's why they show up as comments. There are no changes that were made in response to those comments.
Okay, great. Thanks, Amy. That really helps.
Sure.
So I think the next comment is actually on page 22. There's a number of them beginning with NA7. This is a conversation about reciprocity. And there is some feeling that the language in the report did not accurately reflect the discussion and decision-making around the commission. Would anybody like to address this?
Yeah, I'm happy to. That NA7 is mine. I probably a surprise to no one. And I think when I was reading the commission report, it very explicitly states portability probably isn't an option for California for the reasons described. But then it talks about reciprocity and comedy, two very different ideas with potentially different outcomes, and it kind of leaves it vague about where the commission came out on whether or not we would do reciprocity or whether or not we do comedy, although implicitly comedy. If we are eliminating reciprocity, I think we need to be explicit so the public understands that reciprocity is off the table. And I say that as the dean of a California accredited law school, where my graduates are precluded from actually being licensed in certain states, or potentially precluded because they didn't graduate from an ABA accredited law school. So if what the commission is saying is that that's off the table, we're not going to pursue that with states, I'd like to know so that I can clearly dissent. And I'm not really sure what the commission is recommending here.
Chucky, I could maybe fill in a little bit of the a little bit in this here in terms of the context. I think when we talked about reciprocity and comedy, I think we talked about it with all of the caveats. That is, what a policy like reciprocity or comedy would do to non-ABA graduates in California, that potentially those policies would be restricted to only ABA graduates. And so when we had this discussion, we raised that, as well as the fact that reciprocity, obviously is where there's the arrangement between two states and they allow each other entry, right, without an examination. While comedy is where a state allows somebody to be admitted on motion without being extended the same courtesy. And I think the commission itself couldn't narrow down because we don't have one now. So theoretically, it would be hard to select one over the other, right? We don't have those policies as they exist, which is why, and I think they're also, the committee struggled or was challenged with narrowing down what to do for the in terms of a policy for non-ABA law school graduates, which is why I think the recommendation landed where it did, which is that they want us to revise the requirements so that people, out-of-state attorneys, do not have to sit for the California bar exam. They did not address what the implications of that are for non-ABA or law school graduates, nor whether that's comedy or reciprocity, because it really is contingent on the arrangements made between each of those states. So I think it's a broad recommendation for that reason, is that it was a way of not having to nail down some of those other policies. And also the commission had a challenging time determining the requirements, which is the other part of the recommendation is to explore that in the future.
Yeah, and I appreciate that. Unfortunately, this is one of those meetings that I missed. So I wasn't able to fully participate in the discussion or voice my recommendations or concerns about the language that was presented. But to me, the language doesn't read as one in which the BRC is recommending that the state bar explore the possibility of reciprocity. It reads to me as it's, let's figure out who we're going to allow to get licensed in the state of California, not what states are going to allow our graduates to be licensed in their state, regardless of graduate. So it just, to me, reads as comedy, not reciprocity. And I'll make that point in my dissent, because I think the BRC punted because they couldn't figure it out, but the language certainly reads as comedy, not reciprocity. So I'll make that point in my dissent.
Thank you.
Ryan?
Yes, thank you. So I made comment in A8 where I was suggesting that if an out-of-state attorney wants to practice in the state of California without taking the bar exam, a attorney in California in good standing should vouch for that person after a period of time of having worked with them. And the reason why I made that suggestion is because I had mentioned this a couple of times, 2 or 3 times, while the Blue Ribbon Commission was discussing this issue. But our discussions were more broad. We didn't really drill down on specific criteria. But I did want to highlight one interaction I had. It was with I believe it was an appellate court justice from like Missouri. We were talking about the code of civil procedure. And she basically said that in their state, in their jurisdiction, they didn't have all of the rules that we have in California regarding, litigation, court timelines, things like that. Like we have the CCP, rules of court, local rules. They don't have those things. And so as a litigation attorney, if you're not mindful of those things, your client could lose a case on a procedural issue. And so someone out of state needs to at least have some sort of introduction into those issues before giving license to practice on motion. And that's the basis behind this recommendation that I made in the report, and also that I discussed during the commission's deliberations. But I do know we kept it broad. So I'll end with that.
Yeah, I think my recollection was that was our intent. There's a lot of moving pieces and we chose to keep it broad. And so I think both of those are fair comments, and I urge you to include them in any dissent. I think that's probably the right place for them. Amy or Donna, if you have a different opinion, please at any point express it to folks.
Yeah, I think that sounds appropriate. And also, Brian, in terms of you talked about the specificity of California's Code of Civil Procedure, and that got incorporated. And I think you saw that. And that's a result of your comments related to that on page on the arguments against adoption of the next gen exam. So I just want to clarify that.
All right, thanks.
Mm-hmm.
So I believe all of the comments that were made or suggested language were incorporated for the exam pathway through comment NA8. So if there's anything in the first 21.5 pages anybody wants to address, now is the time, or we're going to move on to the bar exam alternative comments, which begin with NA9. Seeing none, we're going to move on to NA9. I think there's a just broad question that was addressed on a couple of occasions here through comment NA9, 10, and moving forward that I want to discuss a little bit more generally. There was a comment that the bar exam alternative was a lengthy section, and that whether or not we needed that much information. I just want to make it clear to everybody the purpose of this And this is it's a record documenting all of the time that we put in, the information that we heard, the deliberations that we had, and they were extensive. And if someone wanted to pick this up at some point, it should be an accurate depiction of what occurred. So as long as we have that, and to the extent, I do believe there are some specific issues in here that we're going to get to where we probably, in my opinion, may have added a little too much information. And I think we can carve it down without losing the crux of what occurred. So that's kind of my general statement before we dig into the specifics of this section. Ryan?
Yes, so I agree that we should, highlight with some specificity some of the mesh points in debate that we had, but we're not doing that with everything. Like, we're not doing that with civility, for example, but we're doing it with this bar exam alternative. And here is my concern. My concern is more along the lines of, there is so much dedicated to this debate that even though we shot it down as a commission, we are still kind of creating the argument for the reader that, hey, maybe you might want to do this anyway. And this is being done at the same moment in time when, for example, the Blue Ribbon Commission, we were looking and examining this issue. But then on the side, I think there was some type of suggestion by the Board of Trustees to the Supreme Court to move forward with it. And thereby undermining what we're doing with regard to examining this issue. And so it's these things that seem to be that fall under the umbrella of gamesmanship that I'm trying to highlight. And as far as the debate, yeah, maybe some discussion should be happened, not this much.
Judge Reeser?
So I don't see it as gamesmanship at all. I mean, we had an entire subcommittee with, I don't know, at least a half a dozen plus meetings for the bar exam alternative. We did not have subcommittees on civility. It was explored, analyzed, assessed, examined in extraordinary detail. Ultimately, when there was a vote, by my count, it did not prevail by a 9-8 vote. So if that's shooting it down, and if that means that it's not worthy of serious analytical discussion, I would be wrong, because I think it is. It was a legitimate discussion point, series of discussion points. It was the core of what we did. So while I get it, people might not want to talk about it because it didn't pass by a 9-8 vote. I think it's kind of the core of what we analyzed and assessed.
Kristen?
Thanks. So for full disclosure, CA10 is my comment. And I don't have a problem talking about, because we covered so much, and Judge Reeser is right. We had, 12 subcommittee meetings. We covered a lot and we explored a lot. And for me, what was concerning was that after the commission, was unable to come to consensus and was not going to recommend at this time a bar exam alternative, that there was not enough discussion actually given to the reasons why. It felt, to Ryan's point, like we were presenting all the information for why we should, and not sufficient information about why 9 or more commissioners voted against it. And so I agree that it has to be presented, but I think it needs to be balanced. And I didn't feel that it was balanced the way that it was presented currently. So that's why I made the comment that it needs to be balanced. So,
Donna?
Yeah, and I think we will get to that part of Judge Rossi's comment, I'm guessing, in just a bit, where there are a couple of comments that are really talking about the need to expand beyond a sentence. The discussion about the Ontario study and the concerns and the problems that were identified in the Canadian provinces in general and in that study in particular. I personally agree with that. I did want to respond to Ryan in sort of setting out sort of my impression of the point of the public comment and why this is included in the report and what the Board of Trustees or the Supreme Court sort of could do, is going to do with this report, right? So the charge of this commission included looking at the exam as well as an exam alternative. And so that's right what we did. And we launched the 2 subcommittees. We spent a lot of time sort of exploring both of those things. While we today are looking at this report saying we don't want to reevaluate these issues, we want to ensure that this report is reflecting what we talked about. When we put it out for public comment, in my view, what we're doing is saying to the public, here's everything that we heard. Here's what we talked about. Here are the votes that we came to, the recommendations we came to as a result of those conversations that we had. What do you think of our recommendations, right? That's what they're responding to. They're not responding to whether the report is a reflection of what was discussed. They're responding to, the public is responding to the recommendations that are made. Based on those recommendations, when the commission gets back together in April, after the public comment period, then the commission then does have an opportunity to say, do we still agree with that recommendation that we made? And could take the opportunity to, based on the public comment, sort of re-examine some of the recommendations and the perspective that was taken at the time. And so that is why we identified those discussions and what led to the recommendations. It's also why Kristen is absolutely right. Judge Rossi is absolutely right. We need to reflect sort of the negative as much as it was discussed and presented in the commission, and that should not be something that we give short shrift to. But it is the opportunity for the public and the board and the Supreme Court, when the report comes to them, to say, I'm looking at the same information now, and am I coming to the same conclusion?
Natalie?
So I do appreciate the comments about if there's something that's missing that we actually discussed as far as the reasons for voting against the bar exam alternative, that should be included, and that should be easy to identify based on minutes from our conversations. What I don't know if this is how it was intended, but what I don't agree with is making sure that there is equal amount of space in the report for both sides, because I actually believe we spent a lot more time discussing the reasons why a bar exam alternative made sense. Granted, ultimately, that's not what the commission voted for, but as far as points being made, evidence we brought in, et cetera, there was a lot more time devoted in each of those meetings where we discussed this for why it did make sense. So I would urge us, as we finalize this document, not to think about it as, do both sides have equal amount of time or space in the report? It's, does it reflect what the commission did during our meetings, and then identify anything that's missing that did in fact occur during our discussions.
Ryan?
Yes, so I think Donna agreed with Judge Rosie's suggestion that we include information that was omitted that undermined the idea of recommending this bar exam alternative pathway. There's a lot of statistics, in particular with regard to what happened in Ontario, that show why this is a bad idea, that I'm glad to hear are now going to be included in this report. When I made the comment about gamesmanship, it wasn't with respect to anyone on this commission or the commission's work. This commission was created to look at this, and I do think this should be discussed in the report, but in less of an unbiased way. My comment came from the fact that as a member of the California Association of Black Lawyers Legislative Committee, I've been working with members, and their staff have mentioned to me how the bar exam is pushing, how the state bar is pushing this idea of an alternative entry to the profession, and that the state bar is telling them how it's a great idea. That coupled with the Board of Trustees recommending to the Supreme Court to look at this at the same time the Blue Ribbon Commission is working on addressing this issue is the gamesmanship that I'm talking about. So I just wanted to be specific on that.
Okay, thank you. I think the best way forward on this is to start getting to the individual comments with kind of two goals in mind that I hear and I think would be beneficial. One would be to make sure we have a balanced approach. Maybe wasn't meant that way. Omitted to me is usually means intentional, and I don't believe that was the case here. It was if it's not balanced, let's make it balanced. And then second, I think there are a couple of instances where the information is just can be summarized more clearly and more succinctly. And I see no reason not to do that. So let's flip through and see if we can get to some agreement on that, especially to those who made the comments. So the first comment is CA 11 on page 23. There's a question on whether or not Deborah Merritt's information and background shouldn't be earlier in this report. I think it's more specific to exams and of any kind, or I should say competency of any kind, and less specific to what the exam format is. Neil?
Yeah, full disclosure, that was my comment. And I thought, and I could be wrong, that presentation that Dr. Merritt gave was to the exam subcommittee on November 4th, 2021. So that's why that's there.
Amy or Donnie, you have thoughts on that? I mean, I read the section and I understood and agreed with the comment. Was there a reason that it was here and not earlier in the report?
Dr. Merritt presented for both the exam pathway as well as a non-exam pathway, and on at multiple times on both the 12 building blocks and the 10 recommendations. So I think they should probably appear on both. So I think we should.
Yeah, it's fine to move it to that section. I think it was because those that presentation and the building blocks that we talked about and the recommendations were also informative for minimum competence in establishing a non-exam pathway as well.
Okay, Neil?
Yeah, just one more thing. And also, I think what was sort of important about her presentation to the bar exam subcommittee was that she was emphasizing having more performance tests and moving away from memorization. That's part of her Building Better bar exam presentation.
Yeah.
So we can move it to the bar exam section and then include a paragraph to reflect the point that Audrey made about why it was included in this section, that it was also informative in discussing the alternative exam pathway. And so we could just add a paragraph there, but we would move the crux of it to the exam section.
Yes. That would be great.
Yeah, and I have to agree that I hope that we actually expand on it in the alternative pathway piece as well, because I thought her presentation on that really allowed us, for those of us who feel more positively about the alternative pathway, that there was a pathway to actually assess competence in an alternative pathway. And I want to make sure that we give that credence as well, rather than just kind of a line.
Amy, is that understood?
Yes, that's good.
I'm happy. Thank you.
Okay, so we're going to move to page 28, which is the next comment. Comment 12. The first portion of it, I think it's more opinion here. I don't use anything to raise. But again, please include it in dissent if you so choose. If I'm wrong and you think there's language that needs to go, and we can discuss that. I'm going to, otherwise I'm going to move to comment 13. I found, but this is personal commentary here. I did find this section to be a little lengthy, and whether or not we need the entire schedule of the Canadian provinces of a couple of pages. I agreed with some of the comments. Emily?
I'm just wondering if for the things that we don't think belong in the report proper, could we have an appendix that would have this chart so that there is the information that the public can see that we were able to see, but is not front and center in the report?
I can't answer that.
I think that we can add an appendix with the full chart, and we could reduce this down to the provinces we did hear from.
I think that would be important. If we could do those two things, I think it would be helpful. I believe that would cover comment 13, comment 14, and comment 15. Unless there's any additional commentary that anybody wants to make on those three comments, I'm going to move to page 31. There was a comment 16 on page 31, asking for adding pass rates.
So I did look into this since I saw the comment. CA is me, and they don't publish those. The Law Society of Ontario does not publish those. I think anecdotally they said that they were high, but in part it's because people also retake and eventually pass. So they don't publish those. So I doubt they would want us to publish it.
Okay. That would move us to page 33, comment 17.
This one is mine, and I'm not exactly sure how to address it. It just seemed like it was something missing from the report since it's originally in the charge. Either that we didn't spend a lot of time, the BRC didn't spend a lot of time on it, or something to at least acknowledge that it's in the charge, but the BRC perhaps didn't have the opportunity to incorporate it into its discussions. Because I think it's relevant that we didn't for whatever reason. And if I'm remembering correctly, we heard a lot of public comment from members of or participants in the PLL. We also know that the State Bar was going through some studies or starting those studies, but they weren't ready for incorporation into our discussions. But it just felt like there was a miss by not at least acknowledging that it was included in the charge, but perhaps not part of our discussion.
So a couple of things. I think one of the things about the PLL program is that we had very preliminary information when we first started the Blue Ribbon Commission. And so we did do a couple of presentations with what little information we had. And so that is something that perhaps if we do this appendix as suggested, maybe we could add it there. And I think the once a Blue Ribbon Commission had embarked and moved on to the non-exam pathway, exploring that pathway. Simultaneously, I think we were preparing for recommendations to the Supreme Court on what to do with the PLL program, to extend it or not. Unfortunately, we never brought that data. So that's a survey data that came back. So I think to add it to this report would be a mistake because it's not something that we brought to the commission.
Absolutely. But I think
maybe we can make put a link to a reference to it or something like that.
Well, I think just because of using the charge as our starting place, to even acknowledge that we weren't able to incorporate it fully into our discussions because the statistics were unavailable. I just a placeholder of sorts for acknowledging that the PLL exists, that it wasn't incorporated fully into the discussion. And certainly we can link to whatever, but I don't feel strongly about that. I think that information will be made available elsewhere. I just think acknowledging it in the report as part of the charge and whether it did or didn't get incorporated into our discussions is helpful.
All right, we can do that.
Emily?
I'm echoing Jackie's comments just because I apparently misunderstood our relationship to the PLL this whole time. I thought when I had asked whether or not we need to be making a recommendation about that, I was told no. So maybe maybe that's still true. Maybe we weren't. But if in fact we could have gotten to it, but didn't because we didn't have the data, I didn't know that. And so it would be great to say something like Jackie's saying, that there were commissioners that absolutely would have liked to look at this issue, but that was not what we ended up being able to do. And that may largely be because we voted down having any alternative pathway anyway. But so anyway, I think if it's going to be in somewhere, I would definitely recommend something related to the PLL, that we did not have the data and or the stomach to look at that issue.
Yeah, I mean, I'm Donna, go ahead.
Yeah, so I just clarify in response to Emily, I don't think the commission was charged to make a recommendation about extension of the provisional licensure program or what it should be, but that we should look at the results and the information that we have as a source of information to help guide some of the recommendations. And it did ultimately become a timing issue. The results of the survey that was done of the provisionally licensed attorneys as well as their supervisors, that information was not ready until very shortly before the Board of Trustees meeting in November. And frankly, there are still cuts of that survey data which are being done by others today. And so we didn't have enough information by the time the commission dealt with that issue.
Yeah, I just have to reiterate, the conversation is making me very uncomfortable because it was made clear to me that the PLL was not part of our charge. We were not making decisions on that. I didn't have the ability to make those decisions. I said that when some PLL members showed up for public comment at one of our meetings. But rather, if there was any information that we had that could be shared with us that could help us in our deliberations for a longer term approach, that we should be using that. And I know we had a little bit, but we were waiting for more and we never really had a chance to deliberate that. So I think I understand the need to address it, but I would be very careful on how we do that, because we really, it didn't play a large role in the conversations we were able to have.
Yeah, and I would be comfortable with acknowledge that while it was in the charge, the information was unavailable to incorporate into our discussions. Because I think that's relevant for the public to know.
So was it in our charge or not? Because I thought, I was with Josh, I thought it wasn't, but.
So
it says to learn from the PLL, so learn, not make a recommendation about.
Okay, I don't know that that's our charge then to make a recommendation. I mean, I was thinking it was recommendation, but I get what you're saying, Jackie.
Donna and Amy, do you feel like you have some guidance on this section?
Yes.
I do. I just want to clarify, because I don't want there to be any confusion or concern about the expectations when we're talking about the appendices. And so I want to make sure that we fully understand what we're putting in the appendices, because it was referenced here as well. It was referenced with regard to the sort of more complete chart of Canadian provinces. It was referenced here in terms of data from the PLL survey. That's not information that was presented to the commission. It is information that exists, but since it wasn't presented to the commission, I want to be clear, is there a suggestion that it is nonetheless included in the appendices or no?
Not for me, but I think it was just what I wanted is to fill the gap about the existing PLL program, about the charge to learn from it, and then it kind of disappears and it's never talked about again, to acknowledge that we were unable to incorporate or have any information presented to inform our discussions about the non-exam pathway. That is what I'm looking for, not to include any data that was not submitted to the BRC.
Thank you. I think that's consistent with what occurred. I'm going to move to page 34. I believe that's the next comment, comment 18. Yeah, but anything before then and you want to raise, please let me know. I think this is the first comment that addresses more specifically a balanced approach than just the number of words and pages. And so I would be in support of adding additional language that voiced some of the concerns that we had. Whoever comment this is, does somebody want to address it? If not, I mean, I do think it speaks for itself to some extent. Is there any reason anyone would have concern adding additional language?
Can we get confirmation that that was actually expressed during our deliberations? I don't remember that comment specifically, but that doesn't mean it wasn't stated then.
We talked about supervisors and abuse of sort of abuse of power, maybe not exactly in these terms. When we talked about the other provinces articling issues and what they have seen over time with their surveys and what they have been doing to address it. So it maybe not exactly as this is stated. And then when we go further in the comments, you'll see there's request to unpack more than that was presented about those issues with articling in Canada. So so kind of, I would say about this comment, we didn't maybe talk about it in light of how I have it in this chart, which is reflected with the guiding principles, but we did talk about supervisors and potential abuses that other that the provinces have seen.
Audrey, let's take a couple of comments and then we can talk about the specific language we're comfortable with if we want to add it. Susan?
First of all, I just want to make sure that we put proper context in. I agree the report should be balanced, but only in the terms that it should be balanced in terms of we did discuss both pros and cons of exam alternatives. But I don't think it should be balanced. And I want to reiterate Natalie's point. A vast majority of our discussions were about the ability to do exam alternatives. And I think it's important that we do not convert balance to mean equal number of pages or equal space, because that would be a revisionist reflection of what the commission actually heard and focused on and spent its time on. So I think it's important we do that. I also think it's incredibly important with regard to this Ontario issue in particular, that we give it proper context. The Ontario representatives, when they were here, raised what they called concerns. I think we have to be very careful not to use inflammatory language, because they didn't say there were abuses. They didn't say there were widespread problems. Instead, the context of these issues was that the Ontario officials simply wanted us to know that when designing a program, these were concerns to consider and that they could be remediated and that they were in fact remediating them. So I think it's important that it have proper context and that it be disclosed in a way that says, yes, this raised concerns, but it was given in the context of how to remediate them, not in terms of these were presented as arguments against exam alternatives, because that's not what was presented.
Kristen?
So this isn't specifically my comment, but one of the later ones on this specific issue is. And I'm not saying that we need to have the same amount of pages in this section on arguments against, but I don't agree with Susan that the Ontario representatives in their studies, are not important or not persuasive or not And because for me, they were actually persuasive. And I don't think that we spend enough time talking about that. And if you do read the full report, there is a significant number of people who talk about sexual harassment, abuse based on, on race, ethnicity, and as the COAF representative, those are issues that are really important. And so I don't want us to gloss over that presentation, because for some of us that presentation was really important. And so I'm not saying equal space in here, but I'm saying we actually have to talk about the things that gave commissioners concerns. And we talked, and I'm one of those people who spoke up and said, this gives me pause. And so to the extent that it is, not reflected in the report, I think that doesn't do the report justice. So.
Before I turn to Ryan, I just want to comment that I do remember having a dialogue around potential abuse of power, and as COAF that you raised it. I think the last bullet point where it talks about the quality of supervision maybe doesn't cover it, and so I would be personally would accept an additional bullet point of concerns that talked about that abuse of power. Ryan?
Yes, not only did we talk about it, but I think the commission talked about this abuse of power issue in 2 separate meetings. In the December 8th, 2021 meeting, there was a presentation by Corey Gitter. I don't know if I pronounced that last name correctly, who talked about the issues going on in Alberta, Canada. Specifically, this presenter referenced that 1/3 of the articling candidates in Alberta reported discrimination and or harassment from their supervisors. On August 16th, 2022, we had a presentation by Priya Bhatia, and Ms. Bhatia reported that there was exploitive working conditions and harassment and discrimination involved with this program. In fact, in the 2017 Ontario study cited that 19% of the candidates reported discriminatory comments or conduct, and 17% reported differential treatment on an enumerated ground. This is just some of the stuff that came to light during these presentations, which give me significant concern. And I am the one that made this comment in A18, because the concerns expressed during these meetings are the reason why I was compelled to make this comment. It might not be in the right section on the draft report, but that's where I was coming from when I made that comment.
Yeah, I mean, I think it is in the right section. Okay. Donna, Amy, I don't know the best way to go about it. I mean, I'm compelled to add one. I know that we had Susan was potentially was looking for more breadth. I don't know if anybody else has any other issues with it. I do agree with the comment that was made earlier, where we have to be careful not to add inflammatory language. But if there's a way that we can address concerns around abuse of power, discrimination, and harassment, that would be, I think, necessary.
Yeah, I certainly think that we can we can accomplish putting in an additional bullet or bullets in this section, using the same tone that we use for all of the bullets that are reflecting those issues. And the reason I'm hesitating as I'm speaking is I'm also looking at the rest of the chart, because during those same discussions, we were also talking about, and I'm not sure if it's reflected in here, the as part of the abuse of power, the inconsistency in pay and whether people were fairly compensated for their work. And that was what led to a follow-up discussion that we had about, well, what does that mean we shouldn't do it, or is there an alternative way around it? Could the state bar require that supervisors pay a fair compensation level? So I think that can also be, that should be included the abuse of power, the risk of discrimination, harassment, and a lack of appropriate compensation should also be in there.
Before I turn to Mylene, when we go down to the next comments, I mean, there is a kind of a summary. And so I think there's going to have to be a balance of what would be added as a bullet point versus what goes into the summary. So we'll get into that in 1 second. Mylene?
I just wanted to weigh in that my recollection wasn't that the Ontario folks came with a host of concerns about their own program that was data driven. So I'm just gonna like to add a thumb on the scale of let's not state what the concerns are voiced via this Ontario report. I'm a little concerned that if we put everything that's in comment 19 into the report, it's going to make it sound a little more data driven than I think it is. For example, when we talk about 19% having experienced a discrimination or something in the articling program, is that compared to how many in outside that program, right? Like it may be that when we look at all of our employers, 19% of folks would feel discriminated against within our institutions. I just want to make sure that we are not overstating the concerns. I guess I'm going back to Susan's point that there's a lot of context here that I feel will be lost if we simply cut and paste what's in the comments into the actual report. I don't remember there being that many concerns by that many commission members at the time of discussion over these issues.
And I don't think that's necessarily our intent. I think the idea here is if there are general concerns that were raised, and we get to CA 19 now on page 35 that can be incorporated so that we just make sure that we have addressed all of them. I too would be pretty uncomfortable around some of the specific statistics, especially because these are very small numbers of groups. We have no ability to completely understand them. But I do think that the points are some important ones. Neil?
Well, actually, so I had played back those presentations that we'd gotten on 2 different occasions from both the folks from Alberta and the other Canadian provinces, and a second presentation given by Ontario later on. The data that you've heard talked about before is based on survey data that they deployed to all those participating in their supervised practice programs during a particular year. I think it was 2017. So I'm not sure why folks think it's something that's not properly data driven, but it's based on survey data of folks in their respective supervised practice programs.
Ryan?
Yes, I just wanted to add an additional measure of context here. So we took examples and data from Canada. I think it's undebatable that it's a lot cheaper to go to college and grad school in Canada than it is in California. The debt load, financial burden shouldered by these candidates for admission is going to be magnified by an exponential number. So the point I'm saying is that these issues of abuse are also going to be magnified, most likely by an exponential number, given that the financial position the candidate is in is going to have an additional role in playing in this context.
Mylene, did you have an additional comment?
Yeah, I just wanted to correct myself and clarify in response to Neil's point. I'm not saying that it's not data driven and that it's an invalid survey. I'm just saying if we are talking about we need to look at the points of comparison. If 18 or 19% felt that they were just given differential or unequal treatment due to personal characteristics within that universe, is that significantly higher than junior attorneys elsewhere in other who are not in that particular articling program? That's all I'm saying, that we need to compare not 19% or 18% to 0, but that number to people in new attorneys in other settings. That's all I'm saying.
So Donna, Amy, do you have any suggestions on how we can incorporate comment 19 into this summary paragraph?
Go ahead.
No, Audrey, you go.
Sorry, I think it's really to expand the paragraph to include more of those points that were made in the survey and the presentation that we received from Priya Bhatia when she came to the Blue Ribbon Commission.
And we can sort of listen back on that presentation and look at the materials that she provided, if there were any, I just don't recall. So we can see exactly what the commission was presented with and make sure that it's appropriately referenced.
And Josh, I know you didn't call on me, but I would say we would not take verbatim this comment 19. We'd have to take the spirit of it without some of the conclusory statements like the significant harassment and abuse candidates face, because I think there is probably a disagreement about whether 19% constitutes significant. So that's what I would suggest.
Okay, thank you. Jackie?
Yeah, and I think this is, for me, a place where the lack of data from the PLL or other programs like it stands out. So I would welcome a thing saying that that the State Bar does not yet have any information to reflect similar behaviors or problems exist in the PLL program, or something like that, because we're very focused on the Law Society of Ontario, and they have great data, but it's the only source of data that we have. And I guess I'm uncomfortable with the idea that this is what swayed people from even exploring an exam alternative this way, when we lack any data that's US based other than what was already acknowledged, which is many of these issues exist in the workplace in the United States, quite apart from any kind of supervised practice pathway. So I guess I would want to acknowledge the lack of US-based data and the lack of California specific data regarding this.
Donna?
So I would note that we do actually now, as a result of the survey that was conducted of the provisionally licensed lawyers, we do have some alternatives with some data that could present a contrary position. The questions asked were likely different, but this was not something that this commission discussed.
Yeah.
And so it wouldn't be appropriate at this juncture to put that in the report.
No, and so I say a lack of data was provided. So with the commission had no data regarding similar programs within the US and or California specifics PLL program.
Yeah, I mean, this is an area, Jackie, I understand where you're going. It's an area, again, that makes me pretty uncomfortable. I think we would have to be pretty clear about then the distinctions between the programs. It's not apples to apples, whether we have the data or lack of data. And so I'm hesitant to do that. I think we can probably, I do believe that there are some issues raised here in the broad concept that need to go into this summary for a more balanced approach. I would be personally hesitant to start relying on data. I understand it was a survey, but I don't think we really dug into it enough. And to your point, don't have additional. So instead of including the data and then addressing that we didn't have other data, I would rather just keep it more broad, personally. Unless someone feels very strong that or a group of folks feel very strong, because specifically on the data, if you wanted to include that in your dissent, anybody has the ability to do that. Ryan?
I feel very strongly for including the data because this is the data we have. I mean, we should not exclude data because we don't have contradictory data. doesn't make sense to me.
Yeah. I think you can, unless someone feels different, I think you can address that in dissent. My reasoning wasn't because we don't have contradictory. It was more about the specifics of this. But nevertheless, if people feel strongly, we can figure out how to build some of it in.
But Josh, I'm sorry, are you talking about the PLL data?
No.
You're talking about these data points in comment 19.
That's correct.
Okay.
That's correct. I think I was, again, this is my opinion. I'm open for anybody else's. I want to steer clear of the PLL data. I have never seen it. I do not know it. To include it in any way, I feel sends the wrong message about not only what our charge was, but what we actually did and deliberated on.
I agree with you. I'm wondering what the concern is about including some of the statistics that are in comment 19. Again, my comment was about maybe some of the expository around it, but the actual data that's in here, assuming it's correct, but just the survey results from the Ontario survey.
Emily?
So at the the top first paragraph of 35, it says Appendix D.
Yeah.
So is that's the Ontario report? Is that where all the statistics would be?
Yeah, so that the 2018 report was looking at this 2017 survey data.
Okay, but so the statistics that are in comment 19 will actually be in Appendix D?
Right.
Correct.
Okay. So is that good enough for folks or no?
Well, I'm just, again, full disclosure, comment 19 is mine. So I'm a little concerned that there's plenty of statistics elsewhere that we put in, but that we're not, this is, I guess this goes to my concern over the flavor, is that we seem hesitant to put in statistics that we don't like, or we dismiss those statistics because we don't know who those 19% are or who those 21% are, or it might have been a small sample size. I feel like I feel like asking someone to go through the 2018 Ontario report on their own in Appendix D is a lot, and I don't think it hurts to put in some of the statistics that are in that report. I don't know why we're afraid to put that in. And I think that it's concerning. That's one of the things that's concerning to me, is that we see, and that's to Ryan's point, I think, of, that it feels like we're picking and choosing the things that we're putting in, and that makes me uncomfortable.
Yeah, that from, at least from my standpoint, that is not the intent. If people want to put in, that's fine. I don't have a recollection of digging into these. That's where my concern was. I remember that we were provided the appendix. I remember that we had general discussions. I don't remember digging into these. And so as I look at them, I read the comment, I started to try to ask myself, how many people were surveyed and what were the questions that were asked? And I don't really remember digging into this. And so did we have dialogue around this? I know we did generally, but around the statistics, and that was my only concern. I have no problem putting it in if that's what people would like to do. I do agree that I want to stay away from more inflammatory language if that's possible. Jackie.
Yeah, and I agree. I have no problem presenting data, because I think the public needs to see everything that the commissioners saw in essence and considered as part of their decision making. I think what I heard Mylin and Susan say was more context. And what I was encouraging was acknowledging the lack of information about US-based or California-specific based similar programs, and that we were relying basically entirely on this Ontario survey, or at least some commissioners were, to inform us about the dangers or potential dangers of this kind of program, and just to have that acknowledged as well.
Amy, Donna, I'm out of ideas on this section.
I mean, I'm just looking back at Priya's
Audrey.
presentation. Sorry.
Yeah, go ahead.
So, and I mean, I think definitely the statistics that she pulls out about that's challenges to articling and survey, I think that makes sense to include, which are some of the similar ones in comment 19, because we all heard them from her presentation.
Like I said, go ahead, Ryan.
Yes, so I mean, so I'm a labor and employment attorney. I do employment law every day. Issues like this come up all the time. I mean, we're not looking at this in a vacuum here. These are folks who are going to work every day. Yeah, they're trying to get a license to practice law, but in this scenario, the power dynamic is exaggerated, especially in California, if we ever did this here, because you'd have a person with $200,000 in debt trying to give validity to their investment into their future at work in a situation where they can be harassed, discriminated against, or otherwise. I mean, we can extrapolate from situations of workplace discrimination, harassment in California in order to see what type of situation we would be in this context.
Jackie?
Yeah, and I don't disagree with Ryan. I think it's a really important issue that would need to be addressed. And if we were to go eventually in the direction of a supervised practice program or something like it, that we would need to figure out how to protect those who were on that pathway from. Absolutely, in no way diminishing the real issues that the Canadian province survey showed, or what happens sadly each and every day in the employment context now for people who aren't in supervised practice programs but are just young licensed attorneys. I think the other thing in terms of context that might be important to make clear is that like every state, Canada's articling program isn't really the same as those supervised practice programs that we have, like Daniel Webster or others in the United States. And the culture is different in Canada. And so I don't know whether we can do an apples to apples comparison. So Ryan's comment may be more relevant because it's US based and even California based than the Ontario survey itself. And I just think it's important that we acknowledge those differences in the context of providing the public this information.
Josh is on mute.
Sorry, I was on mute. Go ahead, Natalie.
So I don't know, Joshua, if this is going to help with helping us to move along, but as guiding principles, as we think about this report, I think it's meant to be a reflection of what the commission considered and deliberated in reaching its recommendations. If that's true, then Audrey just suggested that the staff would go back, look at what was presented to us as a whole, not just what was buried in a report somewhere, because we were exposed to hundreds and hundreds of pages of information. But if it was in the presentation, then it should go in the report. If it was part of a report submitted, then it can be in an appendix somewhere. That's part one. Part two, if we're really going to stick to, if it was presented, it goes in the report, then again, I would say we also have to consider and give weight to what did the committee actually deliberate and discuss. So if they're going to go back and insert additional information, I just want to make sure that someone who's reading this report would also take away from the report. And these are the items that the members of this commission spent time discussing, not just that it was on a slide. So I don't know if that helps or is going to create even more issues. I'm worried that we're beginning to copy and paste when we didn't. I don't even remember us spending a whole lot of time discussing these data points when we were deliberating on the pros or cons of the program. But by going back and inserting a lot of data, it appears as if that was an important piece of our discussion. It might have been an important piece of why folks voted against it, and I'm not discounting that. We all have our own reasons and what persuaded us. But as far as deliberations, that's this document. And I don't want a lot of data to miss that point.
Ryan?
Yeah, I feel like we're constructing these artificial walls about why things should and shouldn't be in the report. Like one wall is if you actually didn't verbalize it in a meeting and discuss it, then it shouldn't be in the report, even though data was presented to us for our consideration. You know, another wall is, you know, like in the kind of, maybe this is a turn off. The first one is like, well, what about things that actually influenced our vote? Like, for example, these numbers, these statistics, the potential for exploitation, harassment, and discrimination to occur, those weigh heavily on my decision to vote against this alternative pathway to licensure, heavily. And I didn't talk about it in great detail during our deliberations, because for me, it became a no-brainer after I was presented with this information.
Can I clarify, Josh?
Yes, please.
Because I definitely don't want to be misinterpreted. What I was saying, Ryan, is if it was included in the presentation that we all saw, whether it was discussed or not, I'm in favor of including it in the report. So that first artificial wall, I think maybe you didn't understand what I was saying, but that's what I meant. If we saw it and it was part of the presentation, it should be in the report, whether deliberated or not. But going back and adding things in a report or going things that were in a report but were not presented to us in committee, that's what I'm saying. I don't think we should go and do that, even if it persuaded one individual member or more, but never discussed. Does that sound different than what I said the first time around at all?
A little bit, but it's okay.
But perhaps then Audrey had come up with a solution, because I think she went back and looked at the presentation. And so maybe the direction should be to add in only those specific data points that were presented to the committee.
And I can tell you what they are if it's helpful. So Priya, that executive director for their professional competence, came on August 16th and presented from that 2017 survey. 19% of respondents reported discriminatory comments or conduct. 17% reported differential treatment based on an enumerated ground. 10% reported remuneration of less than $20,000 per year. Those were the statistics she presented to us in the PowerPoint. And then she talked about what they've done since then, obviously, as well, to address those issues.
Alex, do you have a comment?
Yeah, I do. So I echo a lot of Ryan's sentiment, but for me, discrimination, harassment, and abusive practices really see no extraterritorial boundaries. I don't agree that we should construe relevance to only data that is available in the US. And I appreciate Jackie's comments that it would be helpful to have data from other states, but I don't see how US data, if available, is somehow more valid than survey data conducted in Canada, which really, in the grand scheme of things, involves similarly situated applicants. And I don't recall ever discussing whether other states have conducted surveys of this kind. If so, I don't think it's appropriate to conclude that such data doesn't exist. It's just that we haven't asked or explored whether those data exist in other states. So with that, I'll just yield back my time.
I think we're getting close to a direction here off of Audrey's last comments, but I do want to give Emily a chance to add to her comments.
That was all I was going to say, is that I think we should put in what Audrey just said, because I think that is the pretty much, but Judge Rossi, let us know if it's not, but hits the comments from number 19, very similar data, and puts it in a way that was presented to us. Because I remember having those discussions and those same thoughts that, like, that's something we'd want to look at here, right?
Ryan?
Yes, there was also a presentation on December 8th from Corey Gitter, who said that 1/3 of the candidates reported discrimination and or harassment from their supervisors. So let's not forget that.
So we'll go back and we'll look at the physical PowerPoint presentations, as well as looking at the video. right? Because it could be that there were some statistics that were said out loud that weren't in the written presentation, which I think would merit the same presentation in the report. So we'll make sure that we reflect all of that, and we'll look at, Ryan will look at both of the well, we'll go back and we'll look at any of the committee meetings where this might have come up, committee or subcommittee meetings.
So,
Donna, can we take 1 second here on process, because I understand that you're going to do that, and Audrey is going to do it, and Amy's going to do it, and we are going to attempt to revise this paragraph, taking into consideration the general topics raised in comment 19 and the specific information that was either deliberated and or presented to us in the PowerPoint presentations during the meetings. I guess the question I have is, what happens to that paragraph when it's revised? This is clearly a really important issue for some folks, and I want to make sure that it's addressed appropriately. And I know that we have a timeline also that we're trying to meet, and part of the issue around PLL and otherwise is that this commission has gone much longer than we anticipated. And I know that we're trying to get a report over to the Board of Trustees. So what is the process on that and revision and folks having an opportunity to take a look at the revision?
So after today's meeting, we're going to take all of these comments and the direction that we received today from the commission to go back and revise the report with the idea of getting a draft for public comment by early March, so that we can go out for a public comment period. The end goal is to have a report to the Board of Trustees with a set of recommendations in May. So in March, we would post another version of this report based on the feedback we received today. Go out for a public comment period, a 30-day public comment period in April. We would regroup with the commission one more time to look at the draft before it goes to the Board of Trustees. So there is room to see, there's room for discussion. This commission will see another iteration of this document post us implementing these changes and before it goes to the board. And even when the report goes to the board, there's also another opportunity to submit dissent in the event that comes up.
But I just want to be really clear, the comments that we made, because these are going to be pretty detailed comments that people have asked for in this paragraph. On the time frame you just laid out, you're going to do the best you can based on the general guidance we've given you, and then the report is going to go out for public comment before, according to what you just said, before this commission has another opportunity to comment on it.
Correct. Mm-hmm.
Well, can I just ask my staff team here? We've got 2 more hours for this meeting. Can somebody, maybe Audrey, because I know she dropped it originally, this section, step off and try to work on it and see if we can bring a red line back before the end of this meeting?
Yes, I can do that.
So will that work, Josh?
Yeah, that would work.
All right.
Yeah, that would make me more comfortable if we could allow folks to see what we're talking about before it goes back out to the public.
I just got a quick comment, Josh.
Yep.
I just wanted to take note of what we're saying right now. And it goes back to the whole artificial walls thing. We received so many reports, so many public comments, so many documents. I actually had my assistant print them out and put them in a binder. At the end of it all, I had 2 huge binders of material that I spent on the weekend away from my 7-year-old daughter and 6-month-old son reviewing this work. And what we're saying now is that all that doesn't matter. If it wasn't memorialized in a PowerPoint presentation, it doesn't matter. That is something that I think is wrong. Really wrong, because as commission members, diligent members of this commission, that should matter.
Yeah, Ryan, I can't agree with those comments. I don't think we're saying they don't matter. What we're saying is we're trying to put a report together where, the 18 people that sit on this commission had an opportunity to hear and deliberate. And we're we're trying to get the most summary of those deliberations and the materials that we're seeing. If there's materials that are appendix or we should add as appendix, the record should reflect everything that we looked at and allow somebody to go back and look at the entire record and make a determination on their own, kind of what it sounds like you chose to do this weekend. But before that, we also have an opportunity here to summarize the best we can. So that's what we're attempting to do. So I don't think anything doesn't matter. But I do think we have to synthesize to some degree. Otherwise, we would just be giving the materials over, and I don't think that's a fair result. Audrey, please let me know or let us know when you think you have a red line that we can look at. We can come back to this. I'm going to move to page 36, unless there's something before that anyone else wants to address. There was a comment, it's comment 21 and comment 22. This is an interesting one, because I think we have two opposing views here on these comments. One that wants it more strongly worded and one that prefers a more neutral language. Does anybody want to address these? Emily?
At the risk of trying to eliminate both problems, I would eliminate that section of the sentence. So it would say, while open to hearing about suggested approaches to a supervised practice component, the BRC did not gain consensus on a structure, required number of hours, or potential pilot format.
I don't have a problem with that change. Does anybody else want to address that change, Susan?
Sorry about that, Josh.
All right.
Yes, I want to just support Emily's. I think that redaction hits the right note.
Assuming no additional comments, we're going to keep going. Page 37. There is a comment 23. And the concept under the recommendations considered that maybe we're unintentionally misrepresenting. I don't know whose comment that is on 23. Does anybody want to address that? Comment 23, page 37. Go ahead, Mylin.
That's not my comment, and I also think that that is not correct, right? I mean, my recollection is that the motion or the proposed recommendation that we continue to explore a non-exam pathway was closely defeated, and then a number of times and a number of iterations, and then several iterations of a recommendation that a non-exam pathway not be pursued in any regard was also narrowly defeated. So we ended up not being able to make any recommendation one way or the other. And I think that is the crux of what happened, and that should be clearly stated throughout the report. And I do agree with, I don't know if somebody said this or it was in a comment, that we kind of buried the lead, and we should make that clear up front that the commission couldn't reach consensus, remote consensus, or even a majority vote on either of those two basic concepts.
Yeah, Jackie, right before your comments, I do also agree that we somewhat buried the lead. I think it would be helpful to lead with it and be very clear about where we are. As far as the comment specifically goes, I think there's a little bit of a misunderstanding. The idea, as we were narrowing our options, was that we look at some choices on alternative pathways. We never suggested that they were alternative pathways we were going to move forward with, just that we were narrowing them. And then obviously we know how it concluded. Jackie?
Yeah, and that was gonna be I think it's just a poorly worded sentence, and it comes under something called recommendations considered, and maybe it just needs a little bit more explication. My understanding of this sentence was that we looked at a lot of different potential pathways, and that eventually it got whittled down to 3 that we would consider in terms of voting or further explication. I just think that it is potentially the wording of it, or perhaps because we didn't lead with the conclusion that ultimately the commission didn't find consensus around moving forward. I don't think I would agree with that the entire commission voted to not support. The entire commission did not vote to not support, at least as individual members. But I do think it's a misleading thing, and it might need a little bit further explication.
Okay, Jeremy?
No, thanks, Josh. So this comment 23 is not mine, but I did have the comment earlier as to burying the lead. I forget exactly what I wrote, but that was the comment I put in there. So I think it solves the issue by putting it up front, because it tells the public and California Supreme Court and the Board of Trustees what we did. But I also agree with the assessment that there was 2 motions that were considered, right? One was that there be an alternative pathway that there wasn't a consensus, so it didn't pass. And then there was a second motion that I brought, which was to not consider or to not pursue an alternative pathway, which also did not reach consensus. In other words, did not pass.
I think this is very helpful feedback. We could bring this definitely back. And as Josh, you suggested, maybe start with that lead as in this section. And then also be very clear in this section about the alternate pathways that are described here, that it was a way that we narrowed it down, but to be very clear that while we didn't gain consensus, there also wasn't unanimous vote in one direction or another.
And I think one of the things that might be somewhat confusing about the sentence that comment 23 is referencing is that, and Jeremy, I believe that you were the one who brought this up actually during that particular discussion. We took basically a straw poll on if you had to select between those 3. So one of the options was let's narrow these down to ones that we're going to discuss, but there wasn't an 8th option to vote on at the time of narrow it down to no alternative pathway. And so I think in fairness, we've got to reflect that looking at those 7 options, right? If we were going to authorize one, sort of how would we narrow that down? But with the putting the lead in, I think we can also, that'll also provide some greater context to that. But I think that would be a fairer way to lay out this point.
Yeah, I agree. Thanks, Donna.
Okay.
Donna, does that also cover comment 29 on page 41, what you just recommended?
Let me see. I actually didn't fully understand comment 49. I wasn't sure what should be removed. Was it the motion itself, which I would disagree because it was a motion? I wasn't really following what the recommendation was there.
Yeah, I read it as just the need to clarify specifically what happened. I think if we do that, it should address it.
Yeah, we could definitely make that whole section tighter and cleaner.
The one area where I think we have not addressed yet, there were 2 comments on it. I'm happy to take some comments on it specifically, was including voting or voting totals? I know, I don't know, Donna, Amy, Audrey's probably working on something else. What was your thought process in not including those?
I don't think we have any objection at all to including them. I certainly understand what folks are saying, that to indicate the level of how split the commission was on this issue. It would be helpful to identify the vote tallies. If we do that, we would obviously do that anytime we talk about a vote. We will consistently indicate the what the vote breakdown was. Yes, no, absent, abstain.
Yeah.
So we could do that for all of them.
Two people commented on that. I'd love to hear their thoughts on it. I personally do not believe that it's necessary and think that maybe a more summary point that just says it was closely debated or something of that nature would solve that issue. But I want to address it because it did come up twice. Susan?
I want to speak in favor of vote totals. I don't think it's the same thing to say it was close. Everybody's definition of close is different. I think 9-8 is extremely clear. I think close could be other things. And I think that in terms of transparency, we heard public comment today, and we've heard it at prior meetings, that there are issues of transparency on this commission and its work and the votes. And I think it would be helpful for the report to reflect who voted, and also not by name, but in terms of, present, absent, yes, no. And that way we could have a clear record. And that is the point of a public commission, is a clear and transparent record. And I think there is a difference between characterizing a close vote and showing the public what it was.
Kristen?
So I guess I heard the concerns about the transparency of voting, and I don't have any problems with people knowing how I voted, but I don't understand necessarily. I mean, again, this comes down to what data we're putting in and what data we're not. And when someone wins an election or something passes, we don't always put in the vote right next to it. And putting in the vote rather than saying it was close or it narrowly failed or it narrowly passed, I don't know that that the vote totals do anything except to try and again color the report in a way that I don't see our charges as supposed to be coloring it. It says the recommendation, it says how we, that we voted or this way or we voted that way, but I don't know that vote totals on everything we did is necessary. And to the extent that people are concerned about transparency, who's attending every meeting is in the minutes. It shows right there. And every meeting set of minutes also includes how we voted, and it actually includes how we voted by commission member. So to the extent that that's, again, something that people are concerned about, they could read the meeting minutes, or God forbid they're in the appendix. I'm not even going to say they should be in the appendix, because I don't want the appendix to become this terrible thing. But all of that is somewhere. It's in the meeting minutes. It's in the meeting minutes we just approved. So I don't understand the argument about transparency, and I don't think that putting the vote in every single time does anything except to try and persuade people to do something we couldn't all agree to do. So that's my 2 cents.
Mylin?
Well, I think that all of this, the vote tallies can be discovered through meeting minutes. Those are very hard to get to and let alone compile. A number of people have already asked me, what is the status of the commission and the recommendations? And I have poor Donna and Audrey and Amy know, because I've emailed them more than once about this. I'm having a lot of trouble referring folks who are interested to a website where they can gather that information easily. To get to a vote tally, you have to go through about 11 clicks. And that's if you are already on the commission, so you even know where to go. And so I've been telling people, the information, including, the process that we've gone through, will be in this report. I am strongly in favor of including the vote tallies so that the public can understand without having to do further investigation exactly where we landed and how long it took us.
Jackie?
Yeah, so comment 27 was mine. And for me, I'm a little bit, I'm all for transparency. And that's why I said, hey, if there's data available, let's put data in. If there's a lack of data, let's make that clear as well. And to me, the vote totals are relevant data, whether it's the Ontario information about discrimination or how evenly split the commission was on this particular issue, I think is relevant for the public to know. And just like Ryan was uncomfortable with having people needing to go to an appendix to dig out data that was available to the commissioners, I'm uncomfortable with making people go back and find out where people stood, not as individual members, but in terms of totals. I think it is relevant for the public to know that many of these failed by a 1 or 2 vote margin. And I do think that's important for the public to know. And if it doesn't show up in this report, I will be adding it to my dissent, because to me, it's as relevant as the information regarding discrimination in terms of what went on in this commission.
Emily?
I would echo, and I'd like to have the vote totals in there too. I guess I would say if we are in fact doing an executive summary, which it sounds like we are at the beginning, that if it's just, if the executive summary has our recommendations that and everything we voted on, I guess I would say, and then the vote totals can be there. I don't necessarily need them throughout the entire report, but just so that under somewhere where there's a summary of the recommendations and the votes.
And I'm fine with that, actually, since I'm the only person, and that actually, the vote total comments weren't mine, but if there's an executive summary in the beginning that says each thing we voted on and what the vote total was, that's fine with me. I just don't think it needs to be in the here, but if it's in the summary, that's fine.
Okay, we can make that addition.
Okay, sounds like we have some consensus in adding them and putting them in the summary in the beginning. I believe that's most of the comments. Can we talk about for a moment how the dissents at this stage are going to be treated? Is the intent when this document goes out for public comment to include the dissents in the form they're in this document?
Yes.
Yes, unless somebody wants to revise their dissent or submit a dissent between now and when the report goes out. We realized that we failed to include a comment that was submitted by Judge Reeser that was intended as a dissent. We failed to include that amongst the dissent, so that would be added.
And just for clarification for folks, so it will go out as a dissent at the end of the report. It'll go out for public comment. When it comes back, will they have an opportunity to revise their dissent if they so choose?
Yes, okay. Absolutely.
Can we, unless I get some guidance, Natalie, you had a question?
Just a quick question. Is it too late to submit a dissent?
No, the plan is hopefully to send this report out for public comment, ideally March 6th, no later than March 10. So if you get us something before March 6th, we can incorporate it.
Or revisions to what you've already given will be incorporated.
Josh, if I can just clarify, I think we skipped comments 25 and 26.
Okay.
I'm sorry, yes, 25 and 26.
not intentional.
And that's just about sort of titling, and maybe this is taken care of with the revision to the section by putting the lead in that there was that these motions did not succeed, but this had to do with classifying them as recommendations, and it making and whether we should instead call it failed recommendations or something else.
Okay, does anybody want to address these comments 26 and 27? I apologize that we passed them. It was not intended. Specific to how to tie 26 and 28, maybe.
I think it's 25 and 26.
25 and 26 on the best way to title this section. Yeah, Kristen.
I'm just reading the comments. But I think maybe initial vote or initial motion or initial something, because it does sound like when you say initial recommendation, like that's the initial recommendation of the committee, and it's a little bit confusing. And so if we change it maybe to I don't know that I would say something in here said failed recommendation. I don't know that I would say that. I would just say maybe initial vote or initial motions or whatever.
Yeah, I would agree. I think like motions considered or motions brought kind of tells what the commission was doing.
Yeah, I think that's, I agree. I think it's more clear.
Perfect, thank you.
Are there any specific comments that were not addressed so far in the document that anyone would like to review and address? I want to make sure everything gets covered. If there are, this is a good time to raise them. If not, what I'd like to do is turn to Amy. Are we in a position where we can discuss the timeline? More specifically as to dates? Did I lose Amy?
I'm here. I could pull it up.
Yeah, let's take a minute and do that. And then depending on where Audrey is in the process, I think we could probably take a quick break. And then we can come back and discuss the revised paragraph. Amy, can you walk through for us? I know we touched a couple of these dates, but what this timeline is for the rest of our time under the commission.
Sure. So this is a timeline that notes the final approval of the report to the from the Board of Trustees to the Supreme Court. So as you can see where we're at right now, we're here at February 2023, definitely on the tail end. The idea is for the BRC to review the report, reflecting the recommendations, and to approve the draft that will go out for public comment. So today we received feedback and direction from the commission, and the idea is for staff to go and create another draft and incorporate those comments and that direction into the one that would be posted here for a 30-day public comment period. Donna referred to the fact that we're hoping to get it up by no later than March 10th. So we're aspiring to get it up actually by March 6th. But if we get it up latest on March 10th up on our website for a 30-day public comment period, that would close around April 10th, anywhere between April 6th and April 10th. What we'd like to do at that point is we would bring back the public comments to determine whether there are any modifications that are required before we submit it to the board. In order to do that, we'd like to meet on April 25th is the date that we are suggesting to meet. We will have those public comments, and we will have reviewed them and have proposals like we had today of potential changes or modifications. And so the idea is we would seek the commission's approval at this meeting on April 25th, and then we would bring it to the board for their approval to advance to the Supreme Court at their May 16th or 17th meeting. And the idea also here is that the BRC has another opportunity to submit dissent. We would incorporate that as long as we get it by May 5th. So this is what we're anticipating are as the next steps for this report. And we're going to post this outline on the website on the BRC agenda, just to make sure. We wanted to talk about it before we unveiled that.
Amy, it looks like we have a comment or question.
Okay.
Ron?
Yes, so I unfortunately won't be able to make the April 25th meeting. I'll be in trial, but I did have a question about process. So it was my understanding that this Blue Ribbon Commission was established by the Supreme Court, which is authority over the state bar. And based on this image here, it looks like the commission's findings and final report have to get approved by the Board of Trustees. I mean, that seems like an inappropriate hurdle. And so I just like some commentary on why the Board of Trustees needs to review and approve the Supreme Court's Blue Ribbon Commission recommendations.
So from the start, this was a joint commission of the Supreme Court and the State Bar. And so the Supreme Court was, the State Bar initially approved a draft charter, sent that charter to the Supreme Court for the Supreme Court's final approval. The State Bar solicited, came up with proposed the composition of category composition of members of the commission. The Supreme Court approved that. The Supreme Court was the one who was responsible for selecting the members based on the composition that had previously been approved. But this has always been a joint commission, and so that's why it's going through both of those steps.
Okay, well, one follow-up to that. Since it's my understanding that the Board of Trustees has already recommended to the Supreme Court to look into an alternative pathway to practice, is that somehow going to interfere with the Blue Ribbon Commission's recommendation?
No, I think you're referring to the PLL submission, perhaps, Ryan.
Maybe, I don't.
The board is not going to alter the Blue Ribbon Commission report.
Okay, thank you.
Kristen?
So thanks for pointing that out, Ryan, because I didn't sort of make that connection. So the Board of Trustee review and approval is sort of pro forma, Leah? Is that what you're saying, that they're not going to go into the report and change it?
No, they can't. They're not going to change the report. I think that, there may be some direction about what they'd like staff to include in the cover letter from the board to the Supreme Court. That might be a subject of conversation, but they're not going to change the report.
Okay.
They don't have the ability to change the report.
Okay.
Okay, with that, I think it makes sense for us to take a 15-minute break until 12:45. We'll come back and look at the revised paragraph and make sure that everyone's okay with it, and then we should be able to conclude after that. Does that work, Devin?
Yes, it does.
Okay, perfect. Thank you.
Thank you.
All right, it's 12:45. I think we have most everybody back. Audrey, did you have a chance to revise, and are you the one that will share with the BRC?
Yeah, I have it.
Fantastic.
All right.
Let's, take a look at the paragraph and see if we have any specific comments.
Sorry, ignore one of these footnotes because it's repeated because I cut and paste from the report. So this was the original paragraph. And this is the revision. Do you want me to read? I can read it. Not that I know you're also reading, but the BRC's concerns were driven in part by a 2018 report from the Law Society of Ontario that outlined challenges in the articling program brought to light in a 2017 survey of recently placed articling candidates. Survey results highlighted a number of issues, including the fact that 19% of respondents reported discriminatory comments or conduct, 17% reported differential treatment based on race, class, gender, disability, national origin. Additionally, 10% reported remuneration of less than $20,000 a year, raising concerns about equity and equal access to the program. Further, the 2018 report indicated that the demand for articling positions surpassed the number of available supervisors, again raising concerns about what students had a greater likelihood of access to the program. This is my own note, sorry. Other Canadian provinces, and this is Ryan, where I included the Corey Gitter presentation statistic about their 2019 survey, where about one third reported having experienced some form of discrimination or harassment, either during the articling recruitment process or during their articling term. So we're back here. Other Canadian provinces reported similar issues with articling, and all were working on sourcing more supervisors and adding additional training for them. Since the 2018 report, the Law Society of Ontario has landed on a policy to ensure minimum remuneration standards for all articling candidates, has implemented mandatory training for principals and supervisors, and has begun a process of enhanced oversight and monitoring of placements through audits.
Thank you, Audrey. Ryan. Oh.
Yes, thank you, Audrey. I appreciate you adding both the examples from Alberta and Ontario. The part about what the Canadian bar is doing now since 2018 is not accompanied with any measurable data. So I was wondering what the utility is for including that in this revised language.
So I looked at because that's originally where I had this sentence from. The original was from that presentation and some of the Q&A also from the commissioners back to that executive director for professional competence. And so when she went through these statistics, her next slide was what we've done since, besides the minimum standard of compensation, was also these additional things that were addressing the statistics above. It was part of the presentation.
Okay. All right. So I get that they're making changes, but we don't know if those changes are effective. It's just kind of like they're saying, oh, we did these things, we hope for the best. But how can we use that information in our assessment of a program when all we have from the example is what I call negative information?
So I think in part, yeah, in part the and one of the I don't recall, one of the commissioners sort of made this point earlier, that yeah, these are important considerations that we need to be aware of if we are shaping any program, if there were to be any desire, or if in fact these are important considerations that caused several commissioners to vote against an alternative pathway. However, I think in part what the inclusion of this sentence is leading to is these aren't necessarily death knells to a proposal, because there may be ways to, knowing that these problems exist, there may be ways to address them.
All right, I'll thank you.
Emily?
I just think that in the last sentence, that remuneration should actually be remuneration, as it was in the first. So I just wanted to switch that up.
I was looking at that as well.
Thank you. Any other specific comments to revising the paragraph to the paragraph that Audrey just read to us and is up under the revision on the screen?
Yeah. So, I mean, everything we're doing in our recommendations are evidence-based. That was my assumption. And we're including language in here that's not evidence-based. I just wanted to point that out. I mean, it reminds me of when the NCBE, they were talking about their UBE, their Uniform Bar Exam. They're like, oh, we hope for it to be this and that, but we didn't actually have anything to consider. You know, that's exactly the feeling I'm getting when I read this since the 2018 report language right there. I don't see how that is helpful to our recommendation.
Emily?
One option is to say, since the 2018 report, the Law Society of Ontario has looked at policies to ensure instead of has landed on a policy, because maybe they're just looking at it as we
No, that is actually something they've done. So I guess maybe a different verb is fine if you want, but that has actually happened since 2018.
Well, have they ensured that minimum remuneration standards for all articulating candidates have been implemented?
Yeah, they have a minimum standard now of how much to.
And they've implemented mandatory training, but we don't know if it's actually like addressed some of those other problems, right? I'm just trying to get at Ryan's point, which I understand. If we're just saying, like, even if we just raise these issues, that's I think what the issue is. I don't know that I don't care, honestly, sorry, if Law Society of Ontario has actually done these things. I want them to have, but for our purposes, it's really just the fact that these were examples of how they tried to address these issues. And I think they're good examples. I just think they're examples.
So address these issues by.
I don't know. There's other hands, so I don't know that we need to wordsmith yet,
Okay.
but I'll defer.
Jackie?
Yeah, I want to speak in favor of including this. I think what the commission is talking about when we're talking about a supervised pathway, and if you look at the motions that were presented, they were to explore an alternative pathway to licensure. And what has been identified by Ontario is potential obstacles or things to consider in that exploration. And then what Ontario has also done is say, we identified these issues and we've sought to address them through these particular pathways. To me, that speaks to the idea that if we were to move forward with exploring a pathway, which is the only thing the motions primarily recommended, it would be something to go back to Ontario and say, did these issues actually help decrease the obstacles that you had identified in your 2017 survey? So I actually find this set of sentences very helpful because, again, we're talking about designing a pathway program, and we would want all the information available as part of that. So I'm to me, it's data as well in terms of these are specific steps they've taken, even though we don't have a survey available to us as a commission that told us what the follow-up was.
Kristen?
Thanks. I appreciate you, Audrey, putting this in since I'm the person that raises concern and said I thought that we ought to be including some of this data in here. And my suggestion would be that to the extent that we're talking about, I guess that sentence that begins since the 2018 report. My suggestion would be that we footnote those sentences, and here's why. Because what it feels like is that now we're putting in, and my concern was that we weren't being transparent and putting all the information that we considered in, and so the beginning of it says, BRC's concerns were driven by some of these statistics. Here are the statistics. And it feels like the next sentence, this since 2018 report, is almost an attempt to talk the people out of their concerns. Because here's what Ontario, the Law Society of Ontario is doing, which I don't think is which was not the point in me asking that the data be in here. And the first part is actual data we have. The second part is things that the Law Society of Ontario is doing, which we hope will make, or they hope will make, we all hope, will make a difference. And so that to me isn't data in the sense that we've been talking about data all day, but in fact, maybe, slightly more than conjecture and hopes. And if we're going to leave it in, and I'm not saying we have to take it out, but if we're leaving it in, I think it ought to be footnoted because it takes away from the point of the paragraph, which was to include data that talked about some of the concerns that commissioners had. So I'll leave it at that.
Mylin?
Thanks, Josh. I'm just renewing my objection really for the record to including the precise data, this precise data in this particular format. As formulated, to me, it suggests that the entire commission rejected any kind of non-exam pathway as being more discriminatory than what already exists in the legal profession. I think without the corresponding statistics from elsewhere for junior attorneys, it's misleading. I am looking at a survey right now that says that 36% of junior women attorneys have faced harassment in their workplace. So I don't know that these are significant statistics in reflecting an innate problem of the supervised pathway. I will also suggest that these concerns aren't about any non-exam pathway, they're about the supervised practice pathway. And perhaps if those who are concerned about these effects might have that would be a reason to consider the law school pathway, which we pretty quickly rejected. So I'm just renewing that objection. Thank you.
Ryan?
Thank you, Joshua. So I agree with Judge Christian's recommendation to put that last sentence in a footnote. But I also suggest that we elevate the example from Alberta into the main paragraph, because that's also a numerical statistic that is reliable based on the fact that it was a survey actually conducted. And I also want to point out, like Rule 8.4 G, I believe, in the rules of professional conduct, prohibit discrimination in practice, particularly with regard to employees of a law firm. I think that the situation for this type of alternative pathway to entry would invoke that rule. So we got to be mindful that this issue falls squarely within the jurisdiction of the bar if it ever became a state bar program. And it could impact the state bar's caseload with regard to this issue. Thank you.
Susan?
I think it's important to keep since the 2018 sentence in to give context to the data. I think it's important that we focus not on what the commissioner's reactions were to various presentations, but what was presented. And if people find it more or less persuasive, that is reflected in our votes, and our vote tallies will now be added. But in terms of what we're presenting to the public in the report, it was presented to us that Society of Ontario has actually done these things. And Audrey has removed this material from the presentation itself. And I think we ought to leave it intact the way it is together. And that Ontario was much more of a focus than Alberta. The Alberta footnote is fine. But I think that we need the context of these two things together, the statistics and then what they did in response to it, because that is what commissioners looked at collectively. And some of us decided the remedies were sufficient to continue to explore exam pathways, and others made different decisions. So the decisions that resulted from the data are not going to be reflected in the report. They're reflected in the vote tally.
Okay, so we, without any other comments, we went back, we attempted to revise this. We clearly have a difference of opinion. I take no position on this. I don't know, Amy or Donna, how you want to treat it. I don't know if we don't do it anywhere else. So I'm hesitant to make some commentary in the footnotes about the difference of opinion on it, because once we do that, I think we open ourselves up to doing that in other instances, which we haven't done. Personally, fine with whatever the result is here. So how do you suggest we move forward?
Well, if we have a split of opinion that we can't quite wrap our arms around, we could take a motion on this change. And I guess there are three versions. There's the version as Audrey presented it. There is a version that includes the last sentence, the since 2018 sentence in a footnote. And then there's a version that also includes that since 2018 language in the footnote, but elevates to the text the current footnote about the Law Society of Alberta.
Okay, before we go there, it looks like Neil has a comment.
And I was just going back to my recollection and notes about the presentation that we got from Priya Bhatia from the province of Ontario. So, and I just verified this by actually pulling up the video of the meeting. So what I recall her saying, and this is consistent with the slides that she provided us during this presentation, is that part of the issue that they were trying to deal with supervised practice is that they were using the other programs like the prep program, the law school, additional programs, and that they also had some other practices which they had not implemented yet and would not be actually started to be implemented until May 1st, 2023. Again, I'm just looking back at my notes and looking back at the actual slide deck that she presented to the commission last year. So I don't know, maybe if we're rushing this paragraph too much, and maybe we all need to go back and look at what was presented to the commission, but I'm just trying to present what I remembered and what I'm seeing in terms of what was presented to the commission.
Neil, were you, and I apologize if I didn't connect the dots. Are you suggesting that the last sentence is something they were just considering and had not implemented yet?
They're doing it this year, so that is correct. So maybe the revision that Emily gave me is better, which is what I have now. The creating a policy. So it's this year.
Mm-hmm.
I would still take out the has created, though. I would just say has addressed these issues. Oh, I guess it's creating a policy. I don't know if they've created the policy or if that was this year.
Well, yeah,
go ahead. Sorry.
I was just going to say, I don't know how you say that Ontario's addressed these issues when the policies haven't been implemented yet.
You could say they've responded to it by creating a new policy.
Right, yeah.
Alex?
Yeah, so I'm rereading the Ontario report, and my understanding, and I concur with what Neil said, but I also wonder, just looking at the report again, it seems like they put out 4 different options, one of which is the current model with enhancements. I think that's sort of the one that Audrey may be addressing. Audrey, can I look at the site, the footnote you're citing to? I just want to make sure I understand where you're getting that support from in terms of addressing these issues. I don't think I get from the report that all of these issues have been addressed, even if implemented. Certainly they could implement, whichever option they so decide, but to say that all of these issues have been addressed. Seems like, you know, we have some data point that drives that conclusion, which I don't think we do. Am I right?
So this is an article that I linked to about that minimum compensation that will be implemented this year. And then in the presentation, the other enhancements that they were doing this year, besides the mandatory minimum compensation, included those kinds of training that's being implemented for principals and supervisors. So that was part of what we heard on when was that meeting? Sorry, August 16th.
Can I look at footnote 3? I'm sorry.
That's footnote 3. It's just
see.
repeating because I cut and paste from here.
Got it.
So this is, I don't know how to delete it right now.
No worries. Thank you for the
It's
clarification.
really just these two.
Yeah. Okay.
Other thoughts, comments? So Donna, I don't know the proper way to go about this. Your suggestion is that maybe we take a vote here. It seems to be the one sticking point. And your suggestion is that we would vote on 3 separate motions: the original, the revised, and the revised with a footnote.
Well, and certainly anybody can suggest which, can make a motion that one of those versions we move forward. And then if it doesn't get sufficient votes, just right, we've laid out sort of what are the 3 possible options as we've discussed them. Someone can make a motion for any one of those 3. And then if it fails, then somebody can make a motion for one of the remaining ones. So again, sort of the 3 options it seems that we've talked about are the version as it is on the screen, a version that has that last sentence that says, since the 2018 report, move that to the footnote and leave everything else the same, and a version that also moves that since the 2018 report to the footnote, but elevates to the text the statistic from Ontario, from Alberta. So it seems like those are the 3 options that we're talking about. So if someone wants to make a motion on one of those options, then that's what we would have the vote on.
Okay, I understand. I'm going to turn to Ryan in a second. I mean, I do see that it's appears to be an important issue for both sides. So I personally would love to find any kind of middle ground that exists. But with that, I'll turn to Ryan.
Yes, I move to take that last sentence starting with since the 2018 report to make that into a footnote, and to elevate footnote number 2 to replace that sentence. That is specifically with regard to the Alberta example.
Is there a second to Ryan's motion?
I'll second it.
Roll call vote. Susan Bakshian,
No.
David Boyd,
Yes.
Alex Chan,
Yes.
Charles Dugan, Jeremy Evans,
Yes.
Yes. Apologies. Yes, I had some technical difficulties. This is Charles Duggan. Yes.
thank you. And Jeremy Evans was a yes. Jackie Gardina,
No.
Ryan Harrison,
Yes.
Dr. Henderson,
Yes.
Esther Lynn.
Yes.
Thank you, Dr. Henderson. Esther Lynn, Tracy Montez,
Yes.
Judge Reeser,
No.
Natalie Rodriguez,
No.
Kristen Rossi,
Yes.
Emily Scavalletto,
No.
Karen Silverman, Mylan Spencer,
No.
Amy Williams,
Yes.
Josh Bertula,
No.
back to Esther Lynn. The motion passes.
Okay, thank you. All right, folks, I think that was a final item of business. We should now have a once revised, an updated report that will go out for comment for 30 days. Any other comments before we conclude? Mylin?
Quick question. Can we sign on to somebody else's dissent now that we've read them?
Good question. My only, the staff's got to answer that, but my only concern with that is the dissent may get amended. And so we'd have to come back and make sure everyone was okay with the amendments. Amy or Donna, have you dealt with that before?
Probably, but that seems fine if if you wanted to attach your name to somebody else's dissent to concur in their dissent, if you will. That seems totally fine.
Sorry to jump the line, but it's related to that. Since they may be amended or others might be submitting, would it be possible on, I believe you said by March 6th, we'd have to submit our dissent. Would it be possible on March 7th to quickly circulate what has been submitted? And that way we can see if we're just going to sign on to someone else's at that point.
So I guess the question I would ask is whether the desire is to submit the dissent now before they go out for before it goes out for public comment, or to formally add a dissent with the final report. So after we make any changes to the report based on the public comment and any sort of change in direction that could result in, would that be, a time when you would want to make that dissent, because there's certainly that opportunity, and we would leave time for you to see everybody's dissent so you could add on at that point.
Could I jump in and say I was interested in the earlier stage rather than the later stage?
So we certainly can submit everyone's dissent. The longer it takes to get feedback, the later it will be that we post it. And we just are trying to be very protective of the amount of time it'll take staff to catalog all of the public comments that we receive. And so, if we can have a commitment from you all, as I said, our hope, and I think based on the edits to the report that we talked about today, I think we would normally be in a position to get this out the door for public comment on March the 6th. And so if we could impose on you all, is it reasonable to say if you want to revise the dissent that you've already submitted, or if you want to add a dissent that was not submitted, to send that to us by this Friday? Is that reasonable? And then we could circulate them all on Monday. Everyone can have Monday to review, and then we can finalize the report the next day. Or if it's not reasonable, we can ask you to submit your dissent on March 6th. We'll circulate those dissents immediately on March 6th, and with the goal of posting by March 8th.
Yeah, Donna, there's a lot of different opportunities here. You just need to set the timeline, and people are going to need to abide by it. And to the extent they don't get their opportunity, they will again when it comes back.
So let's say March 6th, dissent has to be in March 6th, morning of March 6th, and we will circulate it that day. Circulate all of the dissents on by midday, March the 6th, and you'll have 24 hours to let us know if you want to add on to anybody's.
Thank you. Jackie?
Yeah, just two things. I think it's always helpful to be reminded of the Bagley-Keene, especially if there's people who want to talk about dissents or disagreements about things that and might be helpful. No serial meetings, right? So no emails, no discussions among members of the group that would equal a majority. Is that correct? Okay. The second thing is, I just wanted to say thank you to the staff. This was, I think, a really difficult report to pull together. I think that you did a great job in terms of taking all of that disparate information and trying to formulate it into something coherent. I think drafting by committee is one of the most challenging things to do. And I think a committee of lawyers just makes it even more so. So kudos to the staff for what you did in the first one and how you've worked with the commission to really come up with the edits that we need to get out. So well done.
Very, very much agree with that. Jeremy.
No, thanks. I just want to echo Jackie's comments, and Josh, thanks for your leadership in this. So, and in no way are our comments to the staff indicative of how we feel about you. So thanks.
Ryan.
Yeah, I just wanted to note for all of the 24 attendees and who are watching this, that we have demonstrated for you how to be civil in the practice of law. There you go.
Great. Okay, folks, that's gonna wrap up our meeting. I have been told we're gonna need a motion to close out the meeting. So meeting's been concluded. If we can have a motion to adjourn.
Motion to adjourn, Jeremy.
Fantastic. Seconded by somebody. I don't think we need a vote on it, just adjourn. Is that correct, Donna?
You do need to vote under the rules that we're using.
We have a little bit of a change here. So let's have a roll call on the motion, please.
Susan Bakshian,
Yes.
David Boyd,
Yes.
Alex Chan,
Yes.
Charles Duggan,
Yes.
Jeremy Evans,
Yes.
Jackie Gardina,
Yes.
Ryan Harrison,
Yes.
Dr. Henderson,
Yes.
Esther Lynn,
Yes.
Tracy Montez,
Yes.
Judge Reeser,
Yes.
Natalie Rodriguez,
Yes.
Kristen Rossi,
Yes.
Emily Scavalletto,
Yes.
Karen Silverman, Mylen Spencer,
Yes.
Amy Williams,
Yes.
Joshua Pertula.
Yes.
The motion passes.
Fantastic. Thanks, everyone. Appreciate your dedication and determination. We will see you all soon.
Thanks all.